The guests of the program are entering the hall, so I request everyone to be seated inside the hall. The program is yet to commence in few minutes. Hello. Let justice be done, though the heavens fall, is a famous quote quoted by Lord Mansfield. A pleasant good morning to all. I am Arolyn D'Souza, the final year LLB student from SDM Law College, Mangalore. Being host of the program, deem it an honor and privilege to welcome all the dignitaries, members of the bench and bar, lecturers, students, ladies and gentlemen to the Golden Jubilee celebration of landmark historical judgment by Supreme Court of India in His Holiness Keshavananda Bharathi Sripadanglavaru and others, and State of Kerala and another, organized by Edneer. Today, it's going to be a special and highly remarkable day to celebrate the victory of our historical landmark judgment. Keshavananda Bharathi and others versus State of Kerala is certainly one of the leading cases in the constitutional history of India. It is the most important judgment of post-independent India, also popularly known as fundamental rights case. It is rightly said that the judgment in the instant case brought an end to the conflict between the executive and the judiciary, and it is proved to be a savior of the democratic system and a setup of our country. The resultant judgment is hard-fought legal battle. The hearing in the case took place with 13 judges, the largest bench ever to sit in the apex court, for 68 long days, and finally a voluminous 703-page judgment was pronounced on 24th April 1973. Today, it is resolved to commemorate the Golden Jubilee celebration in a creative and befitting manner through a seminar on impact of Keshavananda Bharathi. May I now request Advocate Pradeep Rao, KM Bhatt, may I now request KM Bhatt, Advocate Kasaragod, to honor the Honorable Justice Sri Sarasa Venkat Narayana Bhatti, the Judge Supreme Court of India with badge of Organizing Committee. Thank you, sir. May I now request Advocate K.K. Mohammed Shafi, Advocate Kasaragod, Bar Association to honor Honorable Justice Shri N. Nagaresh, the Judge of High Court Kerala, with the badge of Organizing Committee. Thank you, sir. Now may I request to inaugurate the program through Veda Kosha. Let us all kindly rise.
Shri Gurubhyo Namaha. Hare Om. Brahman Brahmana Brahmavarchase Jayatamasmin Rashtre Rajanya Ishavyashura Maharatho Jayatandogre Dhenurvadha Natvanashasaptif Purandhiryosha Jishnu Ratheshtha Sabhejo Yuvasya Yajamanasya Viro Jayatan Nikame Nikamenah Parjanyo Varshatu Phalinyo Na Oshadhayah Pacyantan Yogakshemo Nah Kalpadam. Om Shanti Shanti Shanti. Shriyameva Varundhe Shite Vate Punannivetyaha Kshemo Vairashtrasya Shito Vataha Kshemameva Varundhe. Hare Om.
Prayer is not asking, prayer is putting oneself in the hands of the God. So, to mark the beginning of this auspicious occasion, let us evoke the God's blessings through prayer song by Srimati Usha Bhatt. Let us all kindly rise.
Srimad Priyakaram Ramyam Vidveshadi Vivarjitam Nrinamutsaha Janakam Sopanam Sarvadastunaha Bhuyadhitam Chetasi Modakari Veena Mridangadhvani Datta Saukyam Saubhratra Sauhardatamarurukshataam Saukyapradam Shobhana Akshayam Shubham Saukyapradam Shobhana Akshayam Shubham Saukyapradam Shobhana Akshayam Shubham. Ajnanatimirandhasya Jnananjanasalakaya Chakshurunmilitam yena Tasmai Shri Gurave Namaha. Tasmai Shri Guru Keshavananda Bharathi Namaha. Tasmai Shri Guru Keshavananda Bharathi Namaha.
May I now request Shri K.R. Acharya, Advocate Puttur, the General Secretary of the Organizing Committee, to kindly deliver the welcome address.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ನಮಸ್ಕಾರಂ. ಗುಡ್ ಮಾರ್ನಿಂಗ್ ಟು ಯು ಆಲ್. ಎಡನೀರಿನ ಆರಾಧ್ಯ ದೇವರಾದ ದಕ್ಷಿಣಾಮೂರ್ತಿ ಗೋಪಾಲಕೃಷ್ಣ ಅವರನ್ನು ಸ್ಮರಿಸುತ್ತಾ ಶ್ರೀ ಸಚ್ಚಿದಾನಂದ ಭಾರತಿ ಸ್ವಾಮಿಗಳವರ ಪಾದಾರವಿಂದಗಳಿಗೆ ಸಾಷ್ಟಾಂಗ ನಮಸ್ಕರಿಸ್ತಾ ತಮಗೆಲ್ಲರಿಗೂ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಆಧಾರದ ಸ್ವಾಗತವನ್ನು ಬಯಸಲಿಕ್ಕೆ ತಮ್ಮ ಮುಂದೆ ನಿಂತಿದ್ದೇನೆ. ಪ್ರಾರಂಭಿಸೋದಕ್ಕೆ ಮೊದಲು ಎಡನೀರು ಸಂಸ್ಥಾನದ ಬಗ್ಗೆ ಕೇವಲ 2 ಮಾತುಗಳು. We are all assembled in the precincts of Edneer Mutt. Edneer Mutt needs no introduction. This mutt is situated by the side of river Madhuvahini, which is flowing in the right side of this building. And beyond that, there is one temple which is Kana Shastav temple, situated in the top of the hill amidst thick forest. And in the other side, there is Sri Mahavishnu temple. So, in all, to sum up, this is a scenic beauty. Edneer Mutt is having been established about 1000 years ago by Potakacharya, one of the 4 prominent disciples of Sri Shankaracharya. Since 1961 until 2020, Sri Keshavananda Bharathi Swamy ji held post of Pontiff, known for his forthrightness, his vision, his devotion for art, culture, music, and also especially folklore art, Yakshagana. People, artists from all over India throng into Edneer, especially because they consider it as a seat for their propagation of their art, and having been received here with the utmost dignity. So, such a sacred place it is, and presently, Sri Sachchidananda Swamy ji, having been taken over since 2.5 years, has been doing an excellent job and connects with people of all sorts. Now, the birds of same feather have flocked together here, and we are extremely happy to find amongst us Justice Sri Sarasa Venkatanarayana Bhatti, Judge Justice Supreme Court. In spite of his heavy workload and busy schedule, he has made it over all the way from Delhi with all happiness. First of all, it's my duty to welcome on behalf of Mutt and committee His Lordship Sarasa Venkatanarayana Bhatti.
May I now request I.V. Bhatt, Advocate Kasaragod, to kindly honor Justice Sri Sarasa Venkatanarayana Bhatti with Garland.
Sri Bhatti is born in Andhra Pradesh, graduated law in Jagadguru Renukacharya Law College, Bangalore, enrolled as an advocate in 1987, and started practicing law in Hyderabad. During the year 2013, he has been enrolled as an additional judge and presently elevated to Supreme Court just about 3 months ago. Sir, again, we wholeheartedly welcome you to this August gathering. Accompanying him, his better half, Srimati Anupama Bhatt is also amongst us. I request the committee members.
May I now request Balika ma'am, the Vice Principal of SDM Law College, Mangalore, to florally welcome Srimati Anupama Bhatt.
Thank you. Justice Sri N. Nagaresh, Honorable Chief Justice, Kerala High Court. Sir, your presence is a value addition and has brought laurels. To introduce him, he is alma mater of Bombay University Government Law College, Ernakulam. He was awarded Dr. Kelkar Award for his treatise on Transfer Properties Act. Now we are here to anxious to listen to his keynote address today. So on behalf of Edneer and also Golden Jubilee Committee, we extend hearty and warm welcome to Sri Justice Sri Nagaresh.
May I now request Advocate Shashidhar Kasaragod to honor Justice Sri N. Nagaresh, the Honorable Judge of High Court, Kerala, with the guardland.
Amongst us, Mr. Uday Holla, who is also a star attraction here, and also Mr. Asaf Ali. I extend warm welcome to both of them. I also extend warm welcome to DCH Balkrishna KK, DCH Kasaragod District, and also all the presiding officers. I would be failing in my duty if I don't make mention of advocates of Delhi Bar Association. Believe me, Delhi, Uttara Kannada, Bangalore, Mangalore, Kasaragod, Kanjangad, Beltangadi, Sulya, Bantwal, Udupi, Kundapur, and Kerala, and Mudavidre. And also extend warm welcome to the management people, management of various law colleges, and also teaching faculty of various law colleges, Puttur, SDM Law College, Mangalore, Vivekananda Law College, Puttur, and Manjeshwara Law College, and also KVG Law College, Sulya, and also various good number of students. In spite of having tension of the exams which commence from Monday, they have made it over here. With all the, I extend warm welcome to all of them. And also citizens of Puttur who have come here in good numbers, and also media persons. We are already half an hour late. However, we assure you to make it up. Thank you one and all.
Thank you, sir. On behalf of everyone, I welcome you too. Now may I request Advocate Sri M.K. Narayan Bhatt, Advocate from Kasaragod and the President of the Organizing Committee, to deliver the Presidential Address and give overview about the program.
Sorry, I forgot to mention Shanti Bhushan, Deputy Solicitor General of India, is with us. We extend warm welcome to him. And also Sri K.V. Arvind, Senior Standing Counsel, Income Tax. Hearty welcome to you also, sir. K.V. Arvind, Senior Standing Counsel.
ನಮ್ಮ ಕ್ಷೇತ್ರದ ದೇವರಾದ ದಕ್ಷಿಣಾಮೂರ್ತಿ ಶ್ರೀ ಗೋಪಾಲಕೃಷ್ಣ ದೇವರನ್ನು ಮನಸ್ಸ ಸ್ಮರಿಸಿಕೊಳ್ತೇನೆ. ಶ್ರೀ ಶ್ರೀ ಸತ್ಯಾನಂದ ಸ್ವಾಮಿಯವರಲ್ಲಿ ಸಾಷ್ಟಾಂಗ ನಮಸ್ಕಾರ ಮಾಡಿ ನಿಮ್ಮೆಲ್ಲರನ್ನು ಉದ್ದೇಶಿ ಒಂದೆರಡು ಮಾತು ಹೇಳಲಿಕ್ಕಿದ್ದೇನೆ. ಹಿಸ್ ಲಾರ್ಡ್ಶಿಪ್ ಜಸ್ಟಿಸ್ ಶ್ರೀ ಸರಸಾ ವೆಂಕಟನಾರಾಯಣ ಭಾಟಿ, ಆನರೇಬಲ್ ಜಡ್ಜ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾ, ಮಿಸ್ಟರ್ ಜಸ್ಟಿಸ್ ಎನ್ ನಾಗರೇಶ್, ಆನರೇಬಲ್ ಜಡ್ಜ್ ಹೈಕೋರ್ಟ್ ಆಫ್ ಕೇರಳ, ಶ್ರೀ ಉದಯ ಹೊಳ್ಳ, ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಬ್ಯಾಂಗ್ಳೂರ್, ಫಾರ್ಮರ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಕರ್ನಾಟಕ, Sri Asaf Ali, Senior Advocate, High Court of Kerala and former Director General of Prosecution, State of Kerala, the presiding officers of Kasaragod and Hostur courts, advocates of Kerala, High Court of Kerala, Ernakulam, and High Court of Bangalore, High Court of Karnataka at Bangalore, office bearers of the Bar Associations of Kasaragod District, Dakshina Kannada District, Udupi District, and directors and principals and staff members and students of Sri SDM Law College, Mangalore, Vivekananda Law College, Puttur, KVG Law College, Sulya, and Udupi Law College. We are celebrating my fellow gentlemen, ladies and gentlemen. We are celebrating the Golden Jubilee celebration of the landmark judgment, His Holiness Keshavananda Bharathi Sripadanglavaru and others versus State of Kerala and another. We have thought it fit to bring awareness about the important points raised in Sri Keshavananda Bharathi case among the students and the entire public. The seminars with the presentation of the matter, with the discussion, will help the students and advocates and public to enrich their knowledge. They felt it appropriate to arrange seminars at the apt time of 50 years after the judgment. I feel it my privilege to be with you all on this occasion. We are very fortunate to have with us His Lordship Justice Sarasa Venkatnarayan Bhatti, Honorable Judge Supreme Court of India among us, and also Mr. Justice N. Nagaresh, Honorable Judge High Court of Kerala. We have formed this committee with the association of the Presidents and Secretaries of Bar Associations of Kasaragod District, Dakshina Kannada District, Udupi District, and the Directors Principals of Law Colleges of Manjeshwar, SDM College of Mangalore, SDM Law College Mangalore, Vivekananda Law College Puttur, KVG College of Law Sulya, and Sri Vaikunta Baliga Law College Udupi. His Holiness Sri Keshavananda Bharathi Swamy Edneer Mutt filed a writ petition before the Honorable Supreme Court under Articles 14, 19, 1, 25, 26 and 31 of the Constitution. He prayed for striking out the provision of Kerala Land Reforms Act 1969 to be declared as unconstitutional, ultra-virus and void on the ground that some of its provisions violated the principles of fundamental rights. Indian Parliament passed the 3 constitution amendments in the meantime, that is 24th, 25th and 29th amendment during the pendency of the above petition. Accordingly, the petitioner was permitted to amend the writ petition so as to challenge validity of the 24th, 25th and 29th amendments. Totally 6 petitions were filed and all the 6 petitions were heard together. But the main case was Sri Keshavananda Bharathi case. The Constitution bench of the Apex Court referred the case to a larger bench constituted with 13 judges being the full strength of the then bench of the Supreme Court. The main issue involved therein was as to what is the extent of the amending powers conferred by Article 368 of the Constitution besides Article 13(2) with the Parliament. The case was heard for several months. Eminent jurists Sri N.A. Palkiwala, C.K. Daftari, Mr. M.C. Chagla, Mr. Soli Saurabji, Mr. Amit Dhawan, and Mr. K.J. Harindranath, and other advocates appeared for the petitioners and argued the case. Never in the history of the Honorable Supreme Court of India such legal luminaries were arrayed on either side. Finally, after hearing the matter, the majority of the judges, 7-6, held that Parliament has no power of amending the Constitution so as to take away or abridge the basic structure or framework of the Constitution. Here, I remember the words of jurist Sri Edneer Palkiwala in describing the case. He referred as, history may look upon Keshavananda Bharathi case as the greatest contribution of India to constitutional jurisprudence. These are the words of jurist Edneer Palkiwala. Sri Keshavananda Bharathi Swamy ji is instrumental to the landmark decision to save democracy in as much as the judgment declared that no amendment will be valid if it destroys the basic structure. On 26th November 1975, a bench of 13 judges of the Supreme Court of India assembled to hear the plea of the government of India that the decision of Keshavananda Bharathi case should be overruled. Objections were filed on behalf of the citizens. But after hearing the arguments for 2 days, the bench was dissolved. Thus, the attempt to remove the name of Keshavananda Bharathi from the pages of our constitutional history and attempt to confer an unlimited power on the Parliament to amend the Constitution had a happy end. I think the fitting tribute to Sri Keshavananda Bharathi Swamy ji is, if you are able to start a law college in the name of His Holiness Sri Keshavananda Bharathi Swamy ji at Edneer, we request the blessings of all the legal luminaries and leading personalities in this respect. So, I am very thankful to be with the legal luminaries and getting this occasion, on this auspicious occasion. Thank you, one and all.
Thank you, sir. May I now request the man of distinct vision and a fountainhead of illuminating ideas, an idol of knowledge, His Lordship Justice Sri Sirasa Venkat Narayana Bhatti, the Honorable Judge, Supreme Court of India, to kindly inaugurate the program by lighting the lamp. I request all the dignitaries to join the same. Thank you, dignitaries. May I invite His Lordship Justice Sri Sarasa Venkat Narayana Bhatti to enlighten us with the inaugural address.
Namaste Sharada Devi, Kashmira Puravasini, Twamaham Prarthaye Nityam, Vidyadanancha Dehime. His Holiness Sri Sachidananda Bharathi Swamy ji, my esteemed colleague and brother, Justice Nagaresh, Mr. Uday Holla, the former Advocate General, and Mr. Asif Ali, and several distinguished dignitaries on the dais, and of the dais. My salutations and ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Dear all, I was invited by His Holiness the Pontiff of the Mat to deliver the inaugural speech on the occasion of commemorating 50 years of journey of the Keshavananda Bharathi versus State of Kerala judgment in the annals of Indian legal and constitutional history. I was slightly reluctant, not that I do not want to come to Kasaragod, which is otherwise known as Sapta Sangama, a place where 7 languages flourish, live, float, and enjoy with the beauty of expression in each one of the languages. But the thing is, it's an arduous task to take up a momentous judgment as Keshavananda Bharathi versus State of Kerala and keep the audience engaged at least for a while of 20 minutes. To cover the journey in 20 minutes of Keshavananda Bharathi is a Herculean task. Who are into the thick of practice, they will understand. I say namaste, thank you everyone, and go. I will not be doing the right thing to the responsibility I have accepted on this occasion. And when I accepted the invitation, I thought I am going to see completely new faces with little or no acquaintance. But the warmth with which the Pontiff has received me, and which each one of you extended their warm invitation on my coming to the mat, now makes me feel I am not at all in a strange place or people who I do not know at all. The inaugural speech, I am conscious, is not only for the day. The ambition of present Pontiff, His Holiness Sri Sachidananda Bharathi Swamy ji, is to keep the program alive. Thought the idea should be circulating in the society. With this in mind, if at all I go extempore, it's very likely that I may shoot into the time of my brother Nagaresh, or the other programs will get delayed, or the structured approach which is needed in a basic structure of our constitution may also get slightly diluted or misquoted or whatever it is you call it. The responsibility with which I have to address the gathering is very much present in my mind. The choicest things I have seen in the journey of Keshavananda Bharathi, I would be in a very succinct way sharing my views and ideas with the enthusiastic elderly audience in the first 3/4 of the auditorium, young, energetic and ambitious budding lawyers, students sitting in the last 1/4 of this auditorium. I may compartmentalize my speech into 2 aspects. One, the simple and straight introduction about the mat. 2. The journey of Keshavananda Bharathi in the precedents of all courts, including the Supreme Court, and also, is there any other basic foundation which we have as a culture of India? We call it Indian culture. We have inherited from our forefathers. Is there anything in our individual capacity that each one of us can do to continue to keep that inherited basic capacity or basic structure, develop individually, develop the society, and also develop the country? Now coming back to the prepared speech, I am conscious that today is a momentous day as we assemble at the hallowed grounds of Jagadguru Shankaracharya Samsthanam, popularly known as Edneer Mutt in Kerala and Karnataka, and being part of a year-long celebration of 50 years of Keshavananda Bharathi judgment. I consider it a distinct privilege and an esteemed honor to be with this distinguished gathering. I sincerely appreciate the opportunity extended to me to deliver the inaugural address for today's proceedings and the year-long academic celebrations. Edneer's Mutt history dates back to centuries and stands as a testament to the resilience of our cultural and spiritual roots. To remind myself and the audience, I delve into the origin of the Edneer Mutt and with reverence note that the Mutt was established by His Holiness Sri Totakacharya, one of the 4 original disciples of Adi Shankaracharya, the seer who found the non-dualistic philosophy of Advaita Vedanta, a path of spiritual discipline in which there is no duality between the creator and the created universe. The legacy of Edneer Mutt is interwoven with the values of knowledge, spirituality, and the enlightenment. I have had the opportunity and honor of acquainting myself with and about His Holiness Swamy Keshavananda Bharathi and the Mutt during my tenure as a judge and the Chief Justice of High Court of Kerala. Dear all, we all know the circumstances in which the society grappled to stand on its feet between 20 and 22. Travel was restricted, interaction was restricted. Though there were a few informal invitations to this place, I couldn't make it. I slightly feel sad, and I feel that I missed a good opportunity to meet a great pontiff and a spiritual leader. My knowledge of him may not be complete or comprehensive. Your long association with the Mutt, all of you have mirror reflections of Swamiji, and the occasion is to celebrate the journey of Keshavananda Bharathi judgment. Therefore, by paying my respectful pranams to His Holiness Keshavananda Bharathi, I go to the next stage of my speech. A legal and constitutional principle which has been considered as an axiom on the constitutional principles. The Swamiji, an expert in the music, I am told he is versatile in several arts, but I prefer to say only music, and had profound involvement in Yakshagana, and he has an extended presence in the precedents of the Supreme Court. Thus, he is continuing to live in the history and memory of our nation. Any amount of narrative is like holding candles for the illustrious characters such as Sri Swamy Keshavananda Bharathi, late Sri Nani Palkevala, and all the learned judges on the 13-judge bench of the Supreme Court of India who are part of the fundamental rights case. The fundamental rights case has its own place in the history of democratic and republic India. Nation always acknowledges it. I am delivering the inaugural speech for a year-long celebration of 50 years of the journey of fundamental rights case. The inaugural speech, like a puzzle or a movie teaser. Puzzle is for elders sitting in the first 3/4. Movie teaser is for the youngsters who are sitting in the last 1/4 of the auditorium. It should be like a movie teaser so that the program intended for a year continues to engage the interest of all like-minded people. Thank you. Sorry. Like-minded people, especially students and budding lawyers aspiring to hold constitutional posts. The other speakers on this occasion enjoy the rich experience, and I prefer not to get into the topics they will discuss during the program. I have first-hand knowledge and also experience of my brother, Justice Nagaresh. Any role he accepts, he will satisfactorily discharge it. He has down the road address. I know how he would be taking up a few of the shades of Keshavananda Bharathi judgment. Therefore, I am not touching them also. When I was invited to deliver the inaugural speech, one of my personal experiences about Keshavananda Bharathi versus state of Kerala has come to my mind. This is more to the youngsters who are intently listening to this speech. I relocated my practice from Mufsil Bar in Madanpalli to High Court of Hyderabad, and having started the practice in High Court, I thought the best way to earn the confidence earn the confidence of my senior is to see that whenever he is watching me, read Keshavananda Bharathi versus State of Kerala. My senior, being a smart man, he allowed me to dabble with the book for about 1 month. He never interrupted me. He never discouraged me. He is a man with enormous pragmatic approach in profession. After 1 month, he asked me, yes, how many pages could you read? Sir, still I am taking notes of the majority view, sir. Then he asked me to get into the court. I have found a very good alibi not to get into the court and told him, sir, I will get into court after I finish reading Keshavananda Bharathi versus State of Kerala. All of you know, printed matter, nearly 700 pages. If I had set that task for myself, it would have taken little more longer for me to get into the court and argue a case. Then he said, this is a judgment of momentous importance in the country. Your profession is not for a day or 2 days. As you walk along the path of your profession, you continuously read Keshavananda Bharathi. Every time you read, you will get new idea. Therefore, don't wait to enter the court and argue a matter till you complete Keshavananda Bharathi versus State of Kerala. Then this advice I have taken very seriously, got into profession and started doing my work. Now, coming back to the present generation, they need not have to convince their seniors, like a tough man like Mr. Asaf Ali or Mr. Holla, juniors need not convince them. They will straight away go to Chat GPT. They will ask Chat GPT, tell us what is Keshavananda Bharathi versus state of Kerala. Not only you, even I tried. The majority view, minority view, when I asked, please tell me the journey of Keshavananda Bharathi till date, it has given to me all the important judgments. In a nutshell, it referred to 4 or 5 judgments. The artificial intelligence is identifying this judgment as one of the a principle standing on Gibraltar Rock. You may be wondering, if I excerpt from Chat GPT, it may also give 2 pages, 3 pages. No. You can ask for refined version, you can ask for a very detailed version of all the judgments starting from Keshavananda Bharathi, Indira Gandhi, Minerva Mills, I.R. Coelho, all these things you can ask, it gives in a nutshell. As I am delivering the inaugural speech on this momentous occasion, I am under duty and also obligation to introduce the audience in a very succinct way as to what each one of these judgments stood the day on which the judgment was pronounced, and also how the principle has been traveling along with all of us and continues to be a principle relied on for interpreting the powers of the Parliament and also the scope of judicial review. Now let me introduce you how briefly and precisely Keshavananda Bharathi is summed up by artificial intelligence. In the Keshavananda Bharathi versus State of Kerala case, the ratio decidendi is the establishment of the basic structure doctrine. The basic structure doctrine holds that there are certain features and fundamental principles of the Constitution that cannot be altered or destroyed through amendments by the Parliament. These features constitute the core identity of the Constitution and ensure the preservation of its democratic, republican, and secular nature, as well as the protection of fundamental rights. The specific components of the basic structure doctrine were not exhaustively listed in the judgment, but some of the elements that have been recognized as part of the basic structure over the journey of this precedent is that supremacy of the Constitution, the rule of law, judicial review, separation of powers, federalism, sovereign, democratic, and republic nature of India, secular character of the Constitution, protection of the fundamental rights. What I tried for about a month, wrote down about 10-20 pages notes, is now reduced into 2 paragraphs by artificial intelligence. The basic structure doctrine of the Keshavananda Bharathi case is that the Parliament's power to amend the Constitution is not unlimited. It cannot alter the basic structure or fundamental features of the Constitution. This principle has had a lasting impact on the constitutional law in India, influencing subsequent judgments and the interpretation of the Constitution. The judgment was delivered on 24/4/1973. Today, we celebrate 50 years of contribution of the said judgment to the legal and constitutional history of India. To find the reason why we are celebrating the 50 years of the judgment, in my view, we must walk the journey of the fundamental rights case to know the importance of today's inaugural session. Keshavananda Bharathi versus State of Kerala has been traveling with time by marking its presence in innumerable judgments. By keeping in mind the command of Articles 141 and 142 of the Constitution of India, I find it convenient to refer only to 3 or 4 leading cases to mark its journey. First is Indira Nehru Gandhi versus Raj Narayan and another, reported in 1975 to SCC 159. The 1975 election case, officially known as Indira Nehru Gandhi versus Raj Narayan, is a significant Supreme Court judgment in India. It centered on the election of Prime Minister Indira Gandhi and the subsequent legal challenges, highlighting the judiciary's role in safeguarding democracy, the rule of law, and the Constitution. This case has profoundly influenced the interpretation of constitutional amendments, judicial review, and election conduct in India. Then comes Minerva Mills Limited and others versus Union of India, reported in 1980, 3 SCC 625. Minerva Mills Limited versus Union of India assessed the 42nd Amendment Act's constitutionality, establishing key principles in India's jurisprudence. The court introduced the basic structure doctrine, limiting Parliament's power to preserve fundamental constitutional elements. People who would like to appreciate what has been stated in Keshavananda Bharathi, Indira Nehru Gandhi, and how it has been by a 5-judge bench of the Supreme Court has laid down, I recommend the book written by Andhyarjana, Writing or Making of Keshavananda Bharathi. You will get the full picture of happenings right up to Coelho's case. It emphasized the judicial review of amendments, safeguarding against core structure violations, invalidating provisions validating laws. The court affirmed the judiciary's role. The case also upheld federalism, nullifying clauses, reducing state power, and enhancing central control. Finally, I.R. Coelho versus State of Tamil Nadu, the Supreme Court evaluated the 93rd Constitution Amendment affecting the 9th Schedule's immunity from review. The court upheld the 9th Schedule laws can be reviewed if they breach the Constitution's score. It reasserted limits on amendment power, affirmed judicial review's significance, and emphasized protecting fundamental rights. This verdict reinforced the basic structure doctrine, ensuring judicial authority over laws even within the 9th Schedule. The Coelho case broadened the basic structure doctrine through the effect and impact test, considering an amendment's societal consequences for constitutional validity. The Glenrock Estate Private Limited versus State of Tamil Nadu has clarified on the rights test. It highlighted that an amendment must be directly contravene a fundamental right, not just its essence. While a fundamental right violation might not necessarily breach the basic structure, a law violating the basic structure inherently infringes on fundamental rights. Having broadly referred to 4 judgments, we can understand the importance of Keshavananda Bharathi versus State of Kerala. As I said, nation recognizes it. Having gone this far on the principles laid down in Keshavananda Bharathi, I can wind up my inaugural speech by thanking the Pontiff much for giving me this opportunity. I think then we will not be completely understanding the other basic purpose and essence of our lives also. Dear all, we have inherited great culture, heritage. Name anything that is positive in the world. You have that abundance in this country. We have inherited by merely being the citizens of India. When we cherish, and we would also like to remember the impact of the principle laid down in fundamental rights case. My idea I would like to share with the distinguished guests and audience is that when Justice Mudholkar first contemplated the basic structure, there might have been a few takers for that proposition. As there is basic and inherent strength in it, at relevant time, at relevant hands, the principle has recognized, principle has got the recognition from the Supreme Court of India. If you try to find out what is the basic structure of all our scriptures, when I say scriptures, I am not confining myself to one religion or one place. Puranas, Itihasas, there are so many good things. We have inherited so much of basic ideas, basic structure and strength. While commemorating the journey of Keshavananda Bharathi case, my advice to the younger generation is, you may also explore the possibility of finding out what you have inherited from a great nation like India. What is it so basic for the future of our country, society and yourself? While commemorating, please do this introspection, set your own basic structures, your own basic essences and develop. I can give any number of examples from various quotes and quotes, but I believe in one's own interest and inclination to learn things. As I have shared this idea, now it is for you to take it forward. Before I conclude my inaugural speech, I thank the organization and particularly the Pontiff for making me deliver this inaugural speech of a momentous year-long celebration of Keshavananda Bharathi versus State of Kerala. I particularly thank the audience for having patient hearing in very humid climate and also sweating atmosphere. Thank you, one and all.
Thank you, sir, for the precious inputs. It was a great pleasure to listen to your thoughts with highly inspirational information. We feel honored to have with us the man of skilled experience and inspiration, Justice Sri N. Nagaresh, the Honorable Judge of High Court, Kerala. May I request Your Excellence to deliver the keynote address to the gathering.
पूजनीय स्वामीजी सच्चिदानंद भारती, my Lord Honorable Mr. Justice S.V. Bhatti Sir, Sri K.R. Acharya, Sri Narayana Bhatt, District Judge Balakrishnan, Senior Lawyer of the High Court Asaf Ali, then DSG from Karnataka Shanti Bhushan, Mr. Shyam, eminent lawyers sitting here, senior lawyers, students, brothers and sisters. About 2 months ago, Swamiji asked me to be present in this occasion. But when I stand up here now, I am a little worried. I am worried because from then onwards, I started to think what I will speak here today. But after Honorable Justice Bhatti sir's speech, nothing remains to be spoken about this Keshavananda Bharathi case. Whatever I thought and more has been placed before you by Honorable Justice Bhatti sir with precision, clarity and brevity. Precision, clarity and brevity is the hallmark of Justice Bhatti. When in Kerala High Court, we all judges and lawyers say that whatever you argue in the first 5 minutes, Bhatti sir will understand your case. Your prolonging arguments for 2 hours, 3 hours is not going to help. Such a grasping power. And my lord's judgments are so brief to the core. But beware, mind you, each words used by Bhatti sir would speak volumes in the context. That is why I said I am worried now. I have nothing more to say. But now I would rather opt to speak about not the judgment of Keshavananda Bharathi, but the impact of Keshavananda Bharathi judgment. Just Keshavananda Bharathi's case, Honorable Apex Court said, the Constitution, basic features, basic structure of the Constitution cannot be amended even by Parliament. The basic structure of the Constitution was made by the Parliament with the will of the people. That cannot be changed. This is the crux of the judgment. Now, lawyers and even law students would understand what is the implication and impact of this judgment. Common man may not. Therefore, I would just try to explain it. To understand it, we should know what was the position of India in 1947 when we got independence, and what is the position of India today, and how this 1973 judgment has impacted the sojourn, the democratic process of India. In 1947, when India got independence, the European countries predicted, they made a doomsday prediction that this country, India, is not going to survive as a democratic country for even 5 years. India is going to, as a democracy, India will collapse like a pack of cards in 10 years, if not 5 years. They predicted. They had reason to worry, they have reason to predict also. Because the literacy of India in the year 1947 was 18%. 82% were illiterates. So the Europeans said, see, how can 82% illiterate citizens can bring a democracy forward, take a democracy forward? These people doesn't know even to read the name of their own candidates who are they going to vote. Unless there is a symbol, some cow, sickle, lotus, unless there is some symbol, they cannot even vote. Such illiterate people cannot carry forward a constitutional democracy. That was the first point. Then they said, this is not a nation. India is not a nation. It is a conglomeration of so many countries. They have different cultures. They have different religions. They have a different way of dressing style, different languages, multiple languages. They have different food habits, different kingdoms, different cultures. How such a conglomeration of states can remain as one country in a democracy? So India is going to fall. Then they said, it is a poor country. They do not cultivate, there is no agriculture properly. India government cannot feed its own 38 crores people without importing pulses and wheats from abroad. They don't have. These people are going to die of hunger. We don't produce. India doesn't produce. Then how this democracy is going ahead? There is no health infrastructure in India at that time. Whatever diseases prevalent in any part of the world, those diseases were in abundance in India. Plague, cholera, diphtheria, polio, name it. Everything was there in India in 1947, including tuberculosis. And there was no strong medical support system in India. So how India is going to survive? Any time this country will collapse. They said these people are pagans. These people are pagan. They pray to different gods, multiple gods. They make prayer to the trees. They are praying to animals. Even serpents and rats are their gods. They see river as their goddess. How can these pagans go ahead as a democratic country? Impossible, they predicted. But 75 years later, when we complete the 75 years of Indian democracy, you find out where we are standing now. Our literacy has gone more than 75%. 75%. Large number of scientists, doctors working across the world are Indians, or at least persons of Indian origin. In the field of agriculture, during the war with Pakistan, we had no pulses to eat. We approached America and they gave us wheat. On the basis of their help only India could survive. During that time, Srimati Indira Gandhi, the then Prime Minister of India, she said, no, we are never going anymore with our begging bowl to any foreign country. We will produce agriculture here. We will revolutionize the Indian agricultural sector. A green revolution was brought. Today, we are exporting wheats and pulses and rices everywhere. When problem came to Sri Lanka, India exported. Problems are there in Afghanistan, we are exporting food grains. We are suppliers of food grain. 75 years, when they predicted that these people are going to die with hunger, today we are exporting. They said, you don't have medical infrastructure. Sir, friends, during COVID period we found India produced vaccination, manufactured vaccines for COVID. We exported these vaccines to multiple countries. Today many countries say, unless India had exported COVID vaccine, our situation would have been disastrous. They thank India. India has become a medical destination now. People from various countries, even from Europe, they are coming to India for treatment, especially in the Ayush, Ayurveda and all that. India has turned out to be a medical destination. So this transformation from 1947 to 2023, India in 1947 was a third world country. They didn't say we are first world or second world, third world, underdeveloped, not even a developing country. But today, we are the fifth strongest financial power in India. From nowhere we have reached fifth position. And whom we covered to come to this fifth position, we pushed back the England, the Great Britain, who ruled us for 200 years, to come from sixth position to fifth position. And it is maybe accidental. The Great Britain, the country where sun never sets, is now ruled by a person of Indian origin. In a democratic manner, not using arms and force. In a democratic manner, Indians are being elected as persons of Indian origin, are being elected as leaders by the world. We have now reached moon, South Pole, where no other country has landed. This is our sojourn. This is where India stands now. It is predicted that, even European predicts that, if last century was of belong to Europeans, this century is going to be of Asians. Asians are going to be the superpowers. There are only two choices. One is China, then India. These two countries in Asia will be dominating the world scenario in this century. India is now fifth. It is stated that by 2030, India will be reaching 3. By 2050, whether we will reach number one or number 2 is the question. Yesterday I read the newspapers. China in 2023 pegged their GDP target to 5.5 for the year 2023. After a few months, they revised it, brought it down to 4.5. Now the prediction is China is going to achieve only 3% GDP by the end of the year. Whereas the last quarter's India's GDP is somewhere near 5.72 or so. More than what we expected. So if this trend goes, no wonder India can become number 1. This is the scenario. Now, I ask you, from 1947, when we traveled 75 years, how this became possible? This became possible because of the tremendous service, selfless service of large sections of our Indian population. The farmers, they fought in their agricultural fields to bring about changes, to increase the production. They fought the unpredictable weathers, and now we are exporting pulses. We are exporting pulses. In the field of education, lakhs and lakhs of teachers, gurus, who worked hard, made this possible, that 18% literacy, today it is 75% literacy, more than 75% in India. In the medical field, doctors, nurses, researchers, they made this revolution. India has a very strong infrastructure, medical infrastructure now. I think it's good. They have decided, the government has decided to establish one medical college at least in each district of India, 544 medical colleges. We are going that way. But how this became possible? This became possible because of our constitution, which we adopted, enacted and gave to ourselves in the year 1949. It is this constitution of India which gave rights, fundamental rights to every citizen. Right to equality. Sections of society who were denied education for long 1,000 years, who were discriminated, they had no option, they had no choice, they had no chance of studying, becoming literate. Constitution of India guaranteed that education should be given to all, there should be equality in this area, equality of opportunity in the area of employment. It guaranteed right to life. It guaranteed all fundamental rights. It is this constitution which, along with the tapasya of Indians, 75 years of tapasya of Indian, coupled with this constitution, that has brought this change from 1947 to 2023. Now, the importance of Keshavananda Bharathi case comes. Why this constitution remains so even today? 103, more than 103 amendments we have already amended the constitution, but it is still a live constitution. And believe me, nobody, no force, no majority, no political philosophy, no religious power can change our constitution. Nobody can take the fundamental rights guaranteed by the constitution. Whoever be in power, don't worry. Whichever political party comes into power, don't worry. Whichever religions comes, majoritarian religions tomorrow, don't worry. Because as long as this constitution of India is there, we are going to be governed by rule of law. We are going to get our fundamental rights. We are going to get our equal opportunities for all citizens. And this happened only because of the Keshavananda Bharathi judgment. Keshavananda Bharathi judgment said, don't touch the basic features, basic structure of the constitution. But for Keshavananda Bharathi, I am not sure how long our constitution will survive in this nature. But because of Keshavananda Bharathi, we are all sure that this constitution, with the help of which we traveled from a non-entity in 1947 to a great power, world power in heading G20, a world power in 2023, this happened only because the judgment and Keshavananda Bharathi's case. Without Keshavananda Bharathi's case, I don't think I doubt the sustaining of this constitution. Because Keshavananda Bharathi judgment is there, this constitution will remain, its basic features will remain. It will continue to give us not only fundamental rights, it will continue to lead India to the number one position in the world. This is the importance of Keshavananda Bharathi. With these few words, I thanking Swamiji for giving me this opportunity to speak in this occasion. I stop my speech. Thank you.
Thank you, sir, for gracing and enriching the occasion with your scholarly knowledge. May I now request Advocate Yam Narayan Bhatt, President of the Organizing Committee, to honor Sri Sripadanglavaru Bharathi Swamiji with flowers and fruits. Thank you, sir. May I now request Sri Sripadanglavaru Bharathi Swamiji to give us his blessings by your gracious words.
ओम नमः प्रणवार्थाय शुद्ध ज्ञानैकमूर्तये निर्मलाय प्रशांताय दक्षिणामूर्तये नमः। अत्यंतबालम अतसी कुसुम प्रकाशम दिग्वासदम कनकभूषणभूषितांगम विसृस्तकेशम मरुणाधरम मायताक्षम कृष्णं स्मरामि मनसा नवनीतहस्तम। सदाशिवसमारंभां शंकराचार्यमध्यमाम् अस्मदाचार्यपर्यन्तां वन्दे गुरुपरम्पराम्। Keshavananda Bharathi versus Government of Kerala ಈ ಮೊಕದ್ದಮೆಯ ಫಲಶ್ರುತಿಯ 50ನೇ ವರ್ಷದ ಆಚರಣೆ ಮತ್ತು ಒಂದು ವರ್ಷಗಳ ಪರ್ಯಂತ ನಡೆಯುವಂತಹ ಇದರ ಕುರಿತಾದಂತಹ ವಿಚಾರ ಸಂಕಿರಣ ಮತ್ತು ಇತರ ಕಾರ್ಯಕ್ರಮಗಳ ಕುರಿತಾದಂತಹ ಒಂದು ಸಮಾರಂಭ ಇವತ್ತು ಮಾನ್ಯ ಜಸ್ಟಿಸ್ ಶ್ರೀ ಸರಸ ವೆಂಕಟನಾರಾಯಣ ಭಟ್ಟಿ ಅವರ ಅಮೃತಹಸ್ತದಿಂದ ಉದ್ಘಾಟನೆಗೊಂಡು ಇವತ್ತು ಈ ವೇದಿಕೆಯಲ್ಲಿ ಸಂಪನ್ನಗೊಳ್ತಾ ಇದೆ. ಈಗಾಗಲೇ ಜಸ್ಟಿಸ್ ಸರಸ ವೆಂಕಟನಾರಾಯಣ ಭಟ್ಟಿ ಹಾಗೂ ಜಸ್ಟಿಸ್ ಎನ್ ನಗರೇಶ್ ಅವರು ಅದರ ಬಗ್ಗೆ ಸವಿಸ್ತಾರವಾಗಿ ಆ ಕೇಸಿನ ಬಗ್ಗೆ ಈ ವೇದಿಕೆಯಲ್ಲಿ ಮಾತಾಡಿದರು ಮತ್ತು ಇನ್ನು ಮುಂದೆ ಆ ಕೇಸಿನ ಪ್ರಭಾವ ಮತ್ತು ಪರಿಣಾಮಗಳ ಬಗ್ಗೆ ಖ್ಯಾತ ನ್ಯಾಯವಾದಿಗಳಂತಹ ಶ್ರೀ ಉದಯ ಹೊಳ್ಳ ಹಾಗೂ ಶ್ರೀ ಅಸಫ್ ಆಲಿ ಅವರು ಮಾತಾಡಲಿಕ್ಕಿದ್ದಾರೆ. ಹಾಗಿರುವಾಗ ನನ್ನ ಮಾತನ್ನು ಹೆಚ್ಚು ಬೆಳೆಸದೆ ಇವತ್ತು ಏನು ಕೇಶವಾನಂದ ಭಾರತಿ ಮೊಕದ್ದಮೆ ಇದೆ, ಭಾರತದ ಸಂವಿಧಾನದ ಇತಿಹಾಸದಲ್ಲಿ ಒಂದು ಚರಿತ್ರೆಯನ್ನು ಸೃಷ್ಟಿಸಿದಂಥ ಒಂದು ಮೊಕದ್ದಮೆ ಅದು ಒಬ್ಬ ಸಂತನ ಹೆಸರಲ್ಲಿ ಅದು ಕರೆಯಲ್ಪಡ್ತಾ ಇರೋದು ಖಂಡಿತವಾಗಿ ನಮಗೆ ಧಾರ್ಮಿಕ ವ್ಯವಸ್ಥೆಗೆ ಒಂದು ಹೆಮ್ಮೆಯ ವಿಷಯ. ಆ ಹೆಮ್ಮೆಯನ್ನು ಹೆಮ್ಮರವಾಗಿ ಇರಿಸಿದ್ದು ಆ ಸಂತ ಅವರು ನಮ್ಮ ಸ್ವಾಮೀಜಿ, ನಮ್ಮ ಕಾಸರಗೋಡಿನವರು, ನಮ್ಮ ರಾಜ್ಯದವರು ಮತ್ತು ನಮ್ಮ ದೇಶದವರು ಅನ್ನುವಂಥ ಒಂದು ವಿಷಯ. ಆ ದೃಷ್ಟಿಯಲ್ಲಿ ಇಂಥ ಒಂದು ಮೊಕದ್ದಮೆಯ ಬಗ್ಗೆ ಅದರ 50ನೇ ವರ್ಷದ ಆಚರಣೆಯನ್ನು ಖಂಡಿತವಾಗಿಯೂ ಎಲ್ಲ ನ್ಯಾಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತಹ ವ್ಯಕ್ತಿಗಳಿಗೆ ಅದು ಉಪಯೋಗವಾಗುವ ರೀತಿಯಲ್ಲಿ ಅದನ್ನು ನಡೆಸಬೇಕು, ಅದರ ಕುರಿತಾಗಿ ವಿಚಾರ ಸಂಕಿರಣವನ್ನು ನಡೆಸಬೇಕು ಅನ್ನುವಂಥ ಯೋಚನೆ ಬಂದ ಕೂಡಲೇ ನಮಗೆ ಆತ್ಮೀಯರಾದಂಥ ಕಾಸರಗೋಡಿನ ಕೆಲವು ನ್ಯಾಯವಾದಿಗಳನ್ನು ಸಂಪರ್ಕಿಸಿ ಇದರ ಕುರಿತಾಗಿ ಚರ್ಚಿಸಿದೆವು. ಅದಕ್ಕೆ ಸ್ಪಂದಿಸಿಕೊಂಡು ಕಾಸರಗೋಡು ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಹಾಗೂ ಈಗಾಗಲೇ ಸ್ವಾಗತ ಭಾಷಣದಲ್ಲಿ ತಿಳಿಸಿದಂತೆ ಎಲ್ಲ ಕಾಸರಗೋಡು ದಕ್ಷಿಣ ಕನ್ನಡದ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ನ ಸದಸ್ಯರುಗಳು ಹಾಗೂ ಮಂಗಳೂರು, ಉಡುಪಿ, ಸುಳ್ಯ, ಮಂಜೇಶ್ವರ, ಪುತ್ತೂರು ಲಾ ಕಾಲೇಜಿನ ಆಡಳಿತ ಮಂಡಳಿಯವರು, ಪ್ರಾಂಶುಪಾಲರು, ಇನ್ನಿತರ ಅಧ್ಯಾಪಕ ವರ್ಗದವರು ಅದಕ್ಕೆ ಸ್ಪಂದಿಸಿಕೊಂಡು ಇವತ್ತು ಇಂತಹ ಒಂದು ಕಾರ್ಯಕ್ರಮ ಬಹಳ ಅಚ್ಚುಕಟ್ಟಾಗಿ ಮತ್ತು ಬಹಳ ವೈಭವದಿಂದ ಇವತ್ತು ನಡೀತಾ ಇದೆ. ಈಗಾಗಲೇ ತಿಳಿಸಿದಂತೆ ಏನು ಕೇಶವಾನಂದ ಭಾರತಿ ಮೊಕದ್ದಮೆಯಲ್ಲಿ ತಿಳಿಸಿದಂತಹ ಸಂವಿಧಾನದ ಮೂಲಭೂತ ಆಶಯಗಳನ್ನು ಯಾವತ್ತಿಗೂ ಬದಲಾವಣೆ ಮಾಡಬಾರದು ಅನ್ನುವಂಥ ಒಂದು ಫಲಶ್ರುತಿ ಆ ಕೇಸಿನಿಂದಾಗಿ 1973ರಲ್ಲಿ ಅದು ಪ್ರಕಟಗೊಂಡಿತು. ನಮ್ಮ ದೇಶ ಉನ್ನತವಾದಂತಹ ಸಂಸ್ಕೃತಿಯನ್ನು ಹೊಂದಿರುವಂಥ ದೇಶ ಮತ್ತು ಆ ಸಂಸ್ಕೃತಿಯಿಂದಾಗಿ ಇವತ್ತು ವಿಶ್ವದಲ್ಲಿ ಗುರುತಿಸಲ್ಪಡ್ತಾ ಇರುವಂತಹ ದೇಶ. ಹಾಗಿರುವಾಗ ಈ ಕೇಸಿನ ಫಲಶ್ರುತಿಯನ್ನು ನಾವು ಇವತ್ತು ಗ್ರಹಿಸಿದರೆ ನಮ್ಮ ಏನು ಸಂಸ್ಕೃತಿ ಇದೆ ಕಾಲಕಾಲಕ್ಕೆ ಅದು ಬದಲಾಗಬಹುದು, ಅಥವಾ ವಿದೇಶದ ಸಂಸ್ಕೃತಿಗಳಲ್ಲಿರುವಂಥ ಉತ್ತಮವಾದ ವಿಷಯಗಳನ್ನು ಕೂಡ ನಮ್ಮ ಜೀವನದಲ್ಲಿ ಅಳವಡಿಸಿಕೊಂಡು ನಾವು ಅದನ್ನು ಬದಲು ಮಾಡಿಕೊಳ್ಬೋದು. ಆದರೆ ಏನು ನಮ್ಮ ಮೂಲವಾದಂತಹ ಭಾರತ ದೇಶದ ಸಂಸ್ಕೃತಿ ಇದೆ ಅದು ಖಂಡಿತವಾಗಿಯೂ ಅದರ ಮೂಲ ಆಶಯಗಳು ಹಾಳಾಗಬಾರದು. ಆ ಸಂಸ್ಕೃತಿ ಕಲಾತ್ಮಕವಾಗಿರ್ಬೋದು, ಧಾರ್ಮಿಕವಾಗಿರ್ಬೋದು, ಅದರ ಮೂಲ ತತ್ವ ಅಂತೆಯೇ ಇದ್ದರೆ ಮಾತ್ರ ನಮ್ಮ ದೇಶ ಅದು ವಿಶ್ವಗುರು ಆಗಲಿಕ್ಕೆ ಸಾಧ್ಯ ಉಂಟು ಮತ್ತು ಅದು ಪ್ರಕಾಶಗೊಳ್ಳಲಿಕ್ಕೆ ಸಾಧ್ಯ ಉಂಟು. ಆ ದೃಷ್ಟಿಯಿಂದ ಇವತ್ತು ಇಂತಹ ಒಂದು ಚರಿತ್ರೆಯನ್ನು ಸೃಷ್ಟಿಸಿದಂಥ ಈ ಮೊಕದ್ದಮೆ ಎಲ್ಲ ವ್ಯಕ್ತಿಗಳಿಗೂ ಅದರ ನ್ಯಾಯ ವ್ಯವಸ್ಥೆಯ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಮತ್ತೊಮ್ಮೆ ಅದರ ಪರಿಚಯ ಉಂಟಾಗಬೇಕು, ಅದು ಮತ್ತೊಮ್ಮೆ ಮರುಕಳಿಸಬೇಕು, ಅದರ ನೆನಪು ಅನ್ನೋ ದೃಷ್ಟಿಯಿಂದ ಈ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ಹಮ್ಮಿಕೊಂಡಿದ್ದೇವೆ. ಇದಕ್ಕಾಗಿ ಎಲ್ಲ ರೀತಿಯಿಂದ ಸಹಕರಿಸಿದಂತಹ ಎಲ್ಲ ನ್ಯಾಯವಾದಿಗಳಿಗೆ ವೇದಿಕೆಯಲ್ಲಿ ಇದರ ಪ್ರತಿನಿಧಿಗಳಾಗಿ ಇದರ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಕಾರ್ಯದರ್ಶಿಯವರಿದ್ದಾರೆ. ಅವರೊಂದಿಗೆ ಸಹಕರಿಸಿದಂತಹ ಎಲ್ಲ ನ್ಯಾಯವಾದಿಗಳಿಗೆ, ಕಾನೂನು ಕಾಲೇಜಿನ ಎಲ್ಲ ಆಡಳಿತ ಮಂಡಳಿ ಅಧ್ಯಾಪಕ ವರ್ಗದವರಿಗೆ ಮತ್ತು ನಮ್ಮೊಂದಿಗೆ ಇದರ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ಇದರ ತಯಾರಿಯಲ್ಲಿ ನೇರವಾಗಿ ಸ್ಪಂದಿಸಿದಂಥ ಹಿರಿಯ ನ್ಯಾಯವಾದಿಗಳಂಥ ಅರುಣ್ ಶ್ಯಾಮ್ ಅವರಿಗೆ, ನಮ್ಮ ಆರಾಧ್ಯ ಮೂರ್ತಿಗಳಾದ ಶ್ರೀ ದಕ್ಷಿಣಾಮೂರ್ತಿ ಗೋಪಾಲಕೃಷ್ಣ ಸ್ವಾಮಿ ಆಯುರಾರೋಗ್ಯ ಭಾಗ್ಯಗಳನ್ನು ನೀಡಿ ಹರಿಸಲಿ ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ವಿಶೇಷವಾದ ಪ್ರಾರ್ಥನೆಯನ್ನು ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇವೆ. ಇವತ್ತು ಮುಖ್ಯವಾಗಿ ಇದರ ಉದ್ಘಾಟನೆಗೆ ನಾವು ತಿಳಿಸಿದಾಗ ಬಹಳ ಸಂತೋಷದಿಂದ ಭಾರತದ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರಾದಂಥ ಜಸ್ಟಿಸ್ ಶ್ರೀ ಸರಸ ವೆಂಕಟನಾರಾಯಣ ಭಟ್ಟಿಯವರು ಪತ್ನಿ ಸಮೇತರಾಗಿ ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಪಾಲ್ಗೊಳ್ತಾ ಇದ್ದಾರೆ. ಈಗಾಗಲೇ ಅವರನ್ನು ನೋಡಿದವರಿಗೆ ಅರ್ಥ ಆಗಿರ್ಬೋದು, ಬಹಳ ಸರಳ ಮತ್ತು ಸಹಜವಾದಂಥ ಒಂದು ವ್ಯಕ್ತಿತ್ವ. ಅಂಥವರು ಇಂತಹ ಉನ್ನತ ಹುದ್ದೆಯಲ್ಲಿ ಈ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ಇದ್ದರೆ ಖಂಡಿತವಾಗಿಯೂ ನಮಗೆ ಆ ವ್ಯವಸ್ಥೆಯ ಬಗ್ಗೆ ಧೈರ್ಯ ಮೂಡುತ್ತದೆ ಮತ್ತು ವಿಶ್ವಾಸ ಮೂಡುತ್ತದೆ. ಅಂತೆಯೇ ಜಸ್ಟಿಸ್ ನಗರೇಶ್ ಅವರು ಮಠಕ್ಕೆ ಹಿಂದಿನಿಂದಲೂ ಆತ್ಮೀಯರು, ಬಹಳ ಶ್ರದ್ಧೆಯುಳ್ಳವರು ಮತ್ತು ಭಟ್ಟಿಯವರಂತೆ ಬಹಳ ಸರಳ ಮತ್ತು ಸಹಜ ವ್ಯಕ್ತಿತ್ವದವರು. ಕೆಲವು ದಿನಗಳ ಹಿಂದೆ ನಮ್ಮ ಚಾತುರ್ಮಾಸ್ಯರ ಸಂದರ್ಭದಲ್ಲಿ ಕೂಡ ಬಂದು ಅವರು ಚಾತುರ್ಮಾಸ್ಯದ ಕಾರ್ಯಕ್ರಮಗಳಲ್ಲಿ ಪಾಲ್ಗೊಂಡಿದ್ದರು. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಕಾರ್ಯಕ್ರಮದ ಬಗ್ಗೆ ತಿಳಿಸಿದೆ. ಬಹಳ ಸಂತೋಷದಿಂದ ಅವರ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ಬದಿಗೊತ್ತಿ ಇವತ್ತು ಬಂದು ಇದರಲ್ಲಿ ಭಾಗವಹಿಸ್ತಾ ಇದ್ದಾರೆ. ಅವರಿಗೂ ಮುಖ್ಯವಾಗಿ ಈ ಕಾರ್ಯಕ್ರಮದ ಯಶಸ್ಸಿಗೆ ಕಾರಣರಂಥ ಎಲ್ಲ ಪ್ರತ್ಯೇಕವಾಗಿ ನಾನು ಯಾರನ್ನೂ ಇಲ್ಲಿ ಸೂಚಿಸ್ತಾ ಇಲ್ಲ, ದುಡಿದಂಥ ಎಲ್ಲ ನ್ಯಾಯವಾದಿಗಳಿಗೂ ಇನ್ನಿತರ ವ್ಯಕ್ತಿಗಳಿಗೂ ಇವತ್ತು ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಪಾಲ್ಗೊಳ್ಳುವಂತಹ ಕಾನೂನು ವಿದ್ಯಾರ್ಥಿಗಳಿಗೂ ಮತ್ತು ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕಾಗಿ ದುಡಿದಂತಹ ನಮ್ಮ ಮಠದ ಎಲ್ಲ ಕಾರ್ಯಕರ್ತ ಬಂಧುಗಳಿಗೆ, ಶಾಲೆಯ ಅಧ್ಯಾಪಕ ವರ್ಗದವರಿಗೆ ಮತ್ತೊಮ್ಮೆ ನಮ್ಮ ಆರಾಧ್ಯ ಮೂರ್ತಿಗಳ ಅನುಗ್ರಹವನ್ನು ಕಾಂಕ್ಷಿಸ್ತಾ ಮಾತಿನಿಂದ ವಿರಮಿಸ್ತಾ ಇದ್ದೇನೆ. ಸರ್ವೇ ಜನಾಃ ಸುಖಿನೋ ಭವಂತು. ಓಂ ಶಾಂತಿ ಶಾಂತಿ ಶಾಂತಿ.
Thank you, sir, for gracing the occasion with your gracious words and your blessings. Now may I call upon Advocate Shri Sashindra, Advocate Hosdurg, Vice President of the Organizing Committee, to propose the vote of thanks. May I request Sri Sripadanglavaru Bharathi Swamy to bless the dignitaries with the shawl. May I now request Sri Rajendra Kalluraya sir, the manager of Edneer Mutt, to kindly offer the memento to His Lordship Justice Sri Sarasa Venkat Narayana Bhatti, the Honorable Judge Supreme Court of India. Thank you, sir. May I now request Sir Raj Mohan, Advocate Hosdur. May I now request Sri Sripadanglavaru Bharathi Swamy to bless the dignitaries with the shawl. May I now request Raj Mohan, Advocate Hosdur, sir, to please kindly offer the memento to Justice Sri N. Nagesh, the Honorable Judge, High Court, Kerala. Thank you, sir.
Good morning to everybody. Respected Sri Sripadanglavaru Bharathi Swamy of Edneer Mutt, His Lordship Justice Sri Sarasa Venkat Narayana Bhatti, sir, Honorable Justice N. Nagesh, sir, Judge of High Court of Kerala, Sri M. Narayana Bhatt, sir, who is presided over this function, and Advocate K.R. Acharya, sir, General Secretary, who is addressed the welcome speech, respected District Judge Sri K.K. Balakrishnan, sir, Sri Asif Ali, former DGP, and senior advocates of both Hosdurg and Kasaragod Bar, my colleagues, President and Secretary of the Bar Association Kasaragod, and President and Secretary of Mangalore, and all the students of law in various law colleges, ladies and gentlemen. It is my proud privilege to propose to vote of thanks in this occasion of Golden Jubilee celebration of landmark judgment by Supreme Court of India in Keshavananda Bharathi versus State of Kerala. First of all, I thanks to Sri Sripadanglavaru Bharathi Swamy of Edneer Mutt for giving me an opportunity to give vote of thanks to this function. On behalf of Edneer Mutt, I extend hearty vote of thanks to our chief guest and who inaugurate this function, His Lordship Justice Sri Sarasa Venkat Narayana Bhatti, Honorable Judge of Supreme Court of India, who spent time from his busy schedule to grace this occasion. Today we had an opportunity to hear your thought, and this will surely encourage us in all our future endeavors. You have enlightened our minds and shown us a good future. We have no words to offer gratitude for your valuable presence here. We have deep insight into the topics and revealed some interesting facts. I also want to thank to our Lordship Sri Nagaresh, Honorable Justice of High Court of Kerala, who gave keynote address to this function for his active participation in our function. You fully made this day enlightening for us. Your deep and intellectual way of imparting knowledge has added to the glory of this function. I also thanks to Sri Narayan Bhatt who presided over this function, and also thanks to Sri Advocate K.R. Acharya who has made welcome speech to this function. And special mention and thanks to our district and sessions judge Sri K.K. Balakrishnan, and also Sri Asaf Ali, former DGP, and other dignitaries, and lawyers, law students, and other persons who are present here. Have a good day. Thank you.
Thank you, sir. On behalf of everyone, I thank you too.
I also thanks to the media and also the press.
Here, the inaugural ceremony ends. The dignitaries will be vacating the stage. Let us all stand and bow our respect. In few minutes, please do not vacate the hall. Yes. System in the world. Without the particular judgment by the Supreme Court, the form of Indian judgment would have been totally changed. It is because of the bench's decision that the identity and the spirit of the Constitution have not been lost. This landmark case has given our Constitution the utmost stability. And we can proudly say that it is a privilege to witness this success through the impact of the particular landmark case, Keshavananda Bharathi Sripadanglavaru and others versus State of Kerala and another. Now I would like to invite Advocate Sri Prithviraj Rai, the President of Bar Association Mangalore, to escort the resource persons on the stage. May I now request Sunil Kumar Shetty, the President of Karkala Bar Association, to honor Shri Uday Holla, the Senior Advocate High Court of Karnataka and the former Advocate General of Karnataka with the badge of the Organizing Committee. Thank you, sir. May I now request Advocate Narayan, the President Sulya Bar Association, to honor Advocate Shri Asaf Ali, High Court of Kerala, the former Director of General Prosecutions with the badge of the Organizing Committee. Thank you, sir. Now may I now request Advocate Prithviraj, sir, to welcome the gathering and introduce the subject matter of the program.
Namaskaram. Namaskaraಗಳು. Greetings of the day to all ladies and gentlemen. Today we are here for the inaugural session of the Golden Jubilee celebration of the landmark judgment in the Keshavananda Bharathi case. Right now we had the inaugural session and now we are proceeding to have a seminar on the subject. As far as this seminar is concerned, we have got two important personalities, two great legal luminaries, and it's my duty on behalf of the organizers to welcome the legal luminaries who have come here in spite of their busy schedule to attend this seminar. First, I'll introduce to you our prominent guest from Bangalore, Shri Uday Holla. Uday Holla is the senior advocate from Bangalore. He was the Advocate General for the state of Karnataka 4 times. He is a designated senior advocate. He was born in the year 1951 in Mangalore. That time his father B.P. Holla was a practicing advocate at Mangalore, the bar association for which proudly I can say to which I belong. He was born to B.P. Holla and Vimala Holla. Initial education Shri Uday Holla had in Mangalore. Then his father shifted his practice to Bangalore, so he had to continue his education at Bangalore. Had his BSc degree from the Bangalore University. Studied law at Jagadguru Renukacharya College of Law, Bangalore, with distinction. He secured first rank in his LLB studies. Later on, he did his LLM from the Bangalore University, and it was his habit to gain first rank whenever he was appearing for the law exams. And most importantly, perhaps we'll have to give him a big hand for completing 50 years of legal service, because in the year 1973, he joined the profession, and like we are celebrating this Golden Jubilee of the Keshavananda Bharathi judgment, as a coincidence, we also celebrate his great service to the legal profession for the past 50 years. And Uday Holla is considered to be, or he is a highly respected advocate, and he's having his law firm, Holla and Holla, is one of the leading law firm of India. He is considered to be an expert in corporate, constitutional law, and civil laws. He has authored many articles, and he has attended many numerous national and international legal conferences. He is happily married to Srimati Maya Holla. She is also an advocate. And his son, Vivek Holla, is already making marks at the High Court in Bangalore. He is an advocate, and theirs is a very happy family. And his extended family involves more than 400 juniors who got legal training in his office, and now they have established themselves as prominent advocates in Bangalore and other places. And some of them are even occupying positions in higher judiciary. Uday Holla is a legend of our times, a person with golden heart who associates himself with charitable organizations catering to the aged, orphans, and disabled. So we are very fortunate today that he has come all the way. His time is very precious. I cannot explain how precious it is. Those persons who deal with them know how scarcity of time he is feeling. In spite of that, in spite of his busy schedule and numerous commitments, he has readily agreed and spent a day for us, and he has come here, and I welcome you on behalf of the Mutt, on behalf of the Swamiji, on behalf of the organizers to this function. Thank you, sir, for coming over here.
May I request Sir Sridhar Enmakaje, the Secretary of Mangalore Bar Association, to honor Sir Uday Holla with the garland.
We have another legal luminary from the state of Kerala. He is Advocate Asif Ali. He is a practicing lawyer at the High Court of Kerala. He served as the Director General of Prosecution from 2011 to 16. He also held the post of Special Attorney to Kerala Lok Ayukta and State Public Prosecutor at the High Court of Kerala with special status of Advocate General during the period 2011 to 16. Initially, he enrolled as a lawyer in the year 1981, started practice at Talasheri District Court and in various subordinate courts in southern India, and also practiced before the Honorable Supreme Court of India. It was under his leadership as Director General of Prosecution Kerala, Directorate of Prosecution celebrated 155th anniversary of the Indian Penal Code 1860 with year-long program. He held the post of President of Talasheri District Court Bar Association, and it was under his presidency Talasheri Courts, the second oldest court in the world, celebrated bicentenary with year-long program. He writes in Malayalam and English dailies and periodicals on various legal issues. He is the president of Educational Society New Mahe, which is an approved religious minority educational institution, which was established in the year 1919, which is having 4 educational institutions. He is also the president of Maulana Azad Foundation, Peringadi, and Constitution Club Talasheri, and People's Council for Civil Rights. He held the post of president of India's Lawyers Congress, Lawyers Collective State Committee from 2009 to 2013, 2017 to 2022. Sir, we are very pleased and very happy that you have accepted the invitation on behalf of the Mutt, on behalf of the organizing committee, on behalf of Swamiji, and on behalf of all of us. We welcome you to this gathering as a resource person to take part in the seminar, which will be commencing very shortly.
May I request Shri Uday Krishna, the Principal KVG Sulya Law College, to honor Advocate Shri Asaf Ali with the garland.
Well, now we'll get into the business. The subject of the seminar is impact of Keshavananda Bharathi judgment. It had a huge impact. Though much water has flown down the rear Madhuvahini over the years, even now, yes, we will discuss, or we will get into the seminar. I'm a bit sorry, Swamiji has to leave. He will honor the guests and dignitaries, and after that we'll continue.
I request Shri Shri Sachidananda Bharathi Swamiji to bless the resource persons with the shawl.
Thank you, sir.
Let us all kindly rise.
As you all know, the Keshavananda Bharathi case was the culmination of the struggle between the Parliament and government on the one side and Supreme Court on the other. We have assembled here to celebrate the golden jubilee of the judgment. I am very happy to note that this celebration is being conducted here in such a manner that we have got representatives from Udupi, Kundapur, President of Bar Association of those places have come, and also participation of advocates from Hosdurg Bar Association, which is in the southern tip of the undivided Dakshina Kannada district. We have students from law colleges spread over different colleges in this undivided district, which presently is having 3 revenue districts divided into 2 different states. But one thing which I want to tell before we go into the actual topic is, this undivided district had contributed great personalities who are responsible for framing the constitution. I remember the services of Benegal Narsingh Rao, who was the advisor to the Constituent Assembly, and also remember the service of Benegal Shiva Rao, who also is from this undivided district, was the member of the Constituent Assembly. Then subsequently, I remember a great advocate of this region, M.K. Nambiar, who first propagated the idea of basic structure much before the Keshavananda Bharathi case, and also Justice K.S. Hegde, who was one of the 13 judges who presided over the Supreme Court in deciding the Keshavananda Bharathi case. Sri M.K. Nambiar had one more credit for him, because initially I am told that Keshavananda Bharathi Swamiji initially entrusted the matter to M.K. Nambiar. He was getting old and not capable of moving around. So he prepared brief notes and entrusted the matter to Nani Palkewala, who later on appeared before the Supreme Court. So this region has been very active in the formation of the Constitution and in the development of the constitutional law. So on this occasion, it is very happy to note, after very, very long years, we all from this area have culminated here, and this conglomeration of people from 3 districts gives me immense pleasure to take part in this celebration. As far as the Keshavananda Bharathi case is concerned, though the Parliament represents the sovereign will of the people, the Honorable Supreme Court said that it doesn't have the amending power to alter the basic structure of the Constitution. I told you this decision had enormous effect. We are here to discuss the impact of the judgment. As far as the impact is concerned, it is of multi-dimension. It is not only limited to the happenings inside the court or inside the legislatures. For example, immediately when the government of the time came to know about the impending judgment, immediate appointment of the Chief Justice was made by superseding 3 judges. The government superseded 3 judges because they were not in favor of the government while deciding the Keshavananda Bharathi case. Next, in the year 1975, there was a failed attempt to review the judgment of the Keshavananda Bharathi judgment. Subsequent years, we have seen several judgments. The emergency was imposed, and the government prevailed upon to see that in ADM Jabalpur versus S.S. Shukla, the Supreme Court gave a judgment which is termed by the Honorable Supreme Court itself as an aberration in the constitutional jurisprudence of our country. Then we saw several amendments to the Constitution, and we saw the Supreme Court deciding the case of Indira Gandhi versus Rajanarayan to see whether the fundamental rights enshrined in the Constitution is incorporated or comes within the definition of the basic structure of the Constitution. And subsequently, the Supreme Court in the year 1980 decided the Minerva Mills case, where the 42nd Amendment 42nd Amendment which was passed by the Parliament was nullified, and because it violated the basic structure of the Constitution. So, in the subsequent rulings also, the basic structure has become a Maha Mantra for the Supreme Court. Now, as far as the victory of the judicial system over amending the Constitution is one part, and the other part is, after the Keshavananda Bharathi judgment, we can see a drastic shift in the approach of the government, for example, approach of the courts, because earlier relating to agrarian reforms, economic legislations and reservations, we never found the Supreme Court inclined towards these social objective activities of the government. After the Keshavananda Bharathi case, we see a lot of judgments in which the Supreme Court has recognized agrarian revolution, agrarian economic reforms and reservation systems. Another facet or another aspect which is very important in this regard is, as soon as the judgment was pronounced or about to be pronounced, I explained to you the Chief Justice appointment was made. Subsequently, the Supreme Court, in what is known as Judges' case in the year 1981, 93 and 98, decided that relating to appointment to the higher judiciary, a collegium system has to be introduced. And it introduced, and the appointment of judges is made according to the collegium system. Though initially that system was accepted, later on, because of the defects in the system, defects in the working of the system, it was felt publicly that the system has to be changed. At that time, the government made an attempt to change it, caused an amendment to the Constitution, and National Judicial Appointment Commission was brought into effect. Again, this went up to the Supreme Court, and the Supreme Court held that the principles of separation of power is affected, and that affects the basic structure of the Constitution, and it struck down the formation of Judicial Appointment Commission. So, before I conclude, I would like to say what Justice Chalameshwar in that judgment, a dissenting judgment, wherein the National Judicial Appointment Commission was struck down, he said, it's very important, though judicial independence formed a part of the basic structure, there was abundance of opinion that suggested that primacy to the opinion of the judiciary was not the only way for establishing an independent, efficient judiciary. So, all these matters point us to the fact that somewhere something has to be done. We need a judiciary where the judges can function or discharge their functions with judicial detachment. And we also hear the arguments in the Parliament where we hear our representatives making submissions or making observations in the Parliament stating that the judicial decisions are robbing the powers of the Parliament. And we also have observed what Justice Khanna has said in Keshavananda Bharathi case. Judges, in order to give legitimacy to their decision, have to keep aloof from the din and controversy of the politics. So, the issue is very complicated. What are the impacts, or the impact of Keshavananda Bharathi judgment is enormous. More complication is created by the change of the governments. We always say Parliament and the state, or Parliament and the legislature. But the composition of the Parliament and legislature changes after every election. The judiciary also changes because of the appointment of new judges who take position as the judges. All these complicates the matter still further. But what I feel is that in a democracy, in a democratic system, such difference of opinion must exist. It is a healthy symptom where dialogue and discussion take place, and each organ of the state definitely will try to have its supremacy, whereas the checks and balance in our constitution will not allow any one of the organ to be superior to the other. So that in that background, I think our honorable guests today, Sri Udayholla and Sri Asaf Ali, will be definitely enlightening us with their educative speech or with their talk here, and we eagerly await for their address to the gathering. So I request Sri Uday Holla to begin.
Well, dignitaries on the dais, off the dais, ladies and gentlemen, especially the students. After listening to 1, 2, 3, 4, 5, 6 speeches, I'm sure you are absolutely bored. Pardon me if I will try to be as brief as possible. I've also been a student. Listening to perorations, for 1.5 hours, 2 hours is too much on the young minds. But then, it always inspires me to be before the younger minds. As Justice Bhatti said, this is the era of artificial intelligence. When I came to the bar way back in 1973, in fact, I came 1.5 months after the illustrious judgment, the epoch-making judgment of Keshavananda Bharathi was pronounced by the Supreme Court. In June 1973, I enrolled myself. We were typing on a typewriter. There was no TV. When I was young, there was a radio on the top. Only my father could use it. Today, each one of you are born with the internet, born with, I think, iPhones and iPads. And artificial intelligence is a second part of your life itself. So in this era, what is it that, we elderly people can, give you insight is a question I ponder about it. But the fact is, experience is said is the greatest teacher. 50 years is not a small time. Of course, you may say, oh, well, you're too old. Yes, all of us are old. But then, you will realize, when you come to our age, or after probably another 10 or 15 years, the younger minds, you will realize that experience is the greatest teacher. The constitutional history, if you go back, we got independence in 1947. 1950, we adopted ourselves, the constitution. Thereafter came a series of amendments. The first amendment came in the year 1951. That was because they wanted to bring in certain changes. Certain changes in Article 19. There are certain zamindari systems they wanted to abolish. Agrarian reforms they want to bring in, and therefore they brought in the first amendment. Today, 105th amendment is over. We have completed 105 amendments to the Constitution. As Justice Nargesh said, it is in this background the Constitution remains as it is. Why? Despite 105 amendments, the Constitution stands as a solid rock. That is because of this judgment of Keshavananda Bharathi. Many of us, even I did not know that Keshavananda Bharathi was the pontiff of Edneer Mutt, hailing from South India, that is Kasaragod. We all thought that he was a pontiff of North India. It's a great pride that a saint from this area was able to bring about a constitutional epoch-making judgment. Yes, he lost. Ultimately, what happened was, that was a case where Land Reforms Act of Kerala was challenged, where the mud property was sought to be acquired by the state. He filed the writ petition directly before the Supreme Court under Article 32. While the challenge was there, Kerala government brought about an amendment in 1971. In the meanwhile, there were 3 amendments to the Constitution itself, 24th, 25th and 29th amendments. Imagine, in a matter of 50 to 73, 29 amendments were already over. The petitioner, Sri Keshavananda Bharathi, amended the petition And challenge was made even to this 1971 Kerala law, Land Reforms Amendment. Challenge was made to the 24th, 25th and 29th Amendment to the Constitution. 50 years of this judgment has brought about a sea change. If this judgment was not there, the Constitution would have been defiled and defaced. Every judgment subsequent to Keshavananda Bharathi has borne in mind the principle of Keshavananda Bharathi. It is this which has helped the Indian ethos, the Indian traditions, and the Indian way of thinking. Secularism, rule of law, the distinction between the difference and the difference between the judiciary, the parliament and the executive. All this, they said, is a basic structure. You may look at the judgment of Keshavananda Bharathi. It does not define what is a basic structure, except Justice Jagan Mohan Reddy, in his judgment, refers to some of these elements. I was telling you about the 1951 First Amendment to the Constitution. That again was challenged before the Supreme Court directly under Article 32 of the Constitution of India. 5 judges, a constitution bench, heard that judgment, case. They upheld the First Amendment to the Constitution. That's the Shankari Prasad's case. Thereafter came the judgment in the 1967 Golaknath's case. Golaknath's case was a case where 418 acres and 9.5 units of surplus land belonging to the Golaknath was held to be a surplus land. He again challenged it under Article 32 before the Supreme Court of India. There, the Supreme Court held that fundamental rights cannot be amended at all. There's a shift in Keshavananda Bharathi. Golaknath's case, they overruled Shankari Prasad, but overruled in the sense, they differed from it in certain areas and said that fundamental rights chapter, the parliament has no power to amend at all. Thereafter came the Keshavananda Bharathi's case. As I said, by then, 29 amendments were already over by the time the case was decided. A case which was heard for 68 days. 13 judges, 703 pages of judgment. In fact, as Justice Bhatti was saying, if you look at the SEC book, it is one full book, and that's why Justice Bhatti said he started reading it from this end. Probably it will take you 1 year to complete the reading, to assimilate. Reading may be faster, but to assimilate in what it contains. Shri Palkiwala, Nani Palkiwala, one of the greatest lawyers, argued the matter. On one side was Palkiwala and Daftari and others. On the other side, you had Nirendi, who was the Attorney General at that time. You also had C. Roy, one of the greatest of constitutional lawyers that India had, appearing on behalf of the state, contending that yes, this amendment is valid, that Parliament's right to amend is supreme. What was the argument? What was it that 24th Amendment brought about? 24th Constitutional Amendment, Article 368, we all know, is the clause or the article which permits constitution to be amended. 24th amendment, after the Golaknath's case came about, they wanted to amend the constitution to virtually overrule Golaknath's case. So what did the parliament do? They brought about the 24th amendment to the constitution. What is it? Article 368, as it initially stood, had one article, Article 368(2), the present Article 368(2) was Article 368(1). It merely said it provides for procedure for amendment of the constitution. So in Golaknath's case, they said Article 368 is not a power conferred upon the parliament to amend the constitution. It is a procedure for amendment. So the parliament thought, well, let us do away with this. Let us, cure this lacuna in the constitution. So they said that in Article 368, the heading, they said, the amended provision said, power to amend and the procedure to amend the constitution. Secondly, they also said, in Golaknath's case, the Supreme Court held Article 13 and Article 360. Article 13 specifies that any law that is made by the parliament or the state legislature, if it violates fundamental rights, it is void. So what did they do? The parliament in 24th amendment, they said, all right, we will cure that defect as well, or that lacuna in the constitution. So they said, notwithstanding in the first clause, subclause 2 of, clause 2 of Article 368 was made subclause 2, 1 was made subclause 2. They introduced Article 1, subclause 1, which said, notwithstanding anything contained in the constitution, we have the power to amend. So a non-obstante clause was introduced. Probably in third year, when you have the interpretation of clause, or the fifth year, all of you will, students will realize, a non-obstante clause is used as a tool to ensure that this provision will override the other provisions. So, clause 1 of Article 368 started with the word, notwithstanding anything contained in the constitution. Then they introduced one more clause, clause 4 in Article 368. What is it? They said, 368 power virtually overrides Article 13. I'll not give you the exact word, you can look into it. So virtually they said, 368, notwithstanding Article 13, will the power vest in the parliament to amend. So Article 13 said, any law made, if it violates fundamental rights, is void. So parliament amended this as well. Then they brought about a 25th amendment. What was 25th amendment? Article 19(1)(f) was a right to property. So the Article 31(2) and the link that existed between Article 19(1)(f) and 31(2) was removed. Thereafter, in the same amendment, Article 31(c) was amended. They said, any agrarian reform, if it can't be held to be void if it violates Article 14 and 19 of the Constitution. Article 14 is non-discrimination. Article 19 is the fundamental rights to property and whole host of others, freedom of expression, all that. So this was the 25th Amendment. Then 29th Amendment to the Constitution, passed in 1972. It inserted the Kerala Act, Land Reforms Act, in 9th schedule. You look at the Constitution book, 9th schedule, if it is inserted, any law inserted in the 9th schedule gets a protection against challenge under Article 14 and 19. So they parked that law in 9th schedule. All this was challenged. Palkhiwala argued very, very vociferously. In fact, Justice Khanna, who was a part of that bench, has said this about Nani Palkhiwala. He says, it was not Nani who spoke, much later, much later, not as a judge of the, sitting as a judge of the Supreme Court, but after retirement he said, Palkhiwala who argued, the Nani Palkhiwala, he says, it was not Nani who spoke, it was divinity speaking through him. This was the very words of Justice H.R. Khanna, one of the most celebrated judges that India had, who was a part of the Keshavananda Bharathi's case. What did Palkhiwala argue? Palkhiwala's argument was, there are a couple of them. A few of them are, one, Parliament has no power to destroy or impair essential features, the basic elements or the fundamental principles of the Constitution. Article 368 does not prevail or override Article 13. This was his arguments. Parliament has no power to destroy or impair essential features or the basic elements of the Constitution. The word amendment, Article 368 is amendment. So the word amendment in Article 368 is of an elastic ambit. It would preclude the power to alter or destroy the essential features or the basic elements of the Constitution. So he went on like this. Now on the other side was, he argued for about nearly 30 days. On the other side, you had Sirwai, who, as the Advocate General of Bombay, who argued earlier to Nirendi. In fact, Attorney General always has the priority, but Nirendi was the first one to argue. He said, his argument was that utmost respect should be given or shown to the wisdom of the Parliament, because the Parliament is the will of the people. It represents the will of the people. The courts do not. That was his first argument. Second, he said there should be harmony between the three wings of the state, the Parliament, the executive, the Parliament and the judiciary. There can't be, there has to be harmony. He also went on to state that preamble to the Constitution, because what was held in Golaknath's case and ultimately even here in the Golaknath's case, they said the preamble is not a part of the Constitution. It cannot be amended. That was one of the arguments that Palkhiwala also put forward. So Sirwai's argument and Nirendi's argument was, it's a part of the Constitution itself. He further went on to say that fundamental rights are not human rights. He gave a very beautiful illustration. He says, Article 14, the fundamental rights, today the Parliament, the courts have held even foreigners are entitled to Article 14, non-discrimination. But as it existed then, the law was that foreigners did not have fundamental rights. So the argument of Sirwai was, it is not a human right. If it was a human right, then foreigners also in India would have been entitled to fundamental rights. So therefore it is not a human right. Further he said, the basic features of the Constitution, namely parliamentary democracy, federal structure, rule of law, judicial review, religious freedom, are all not meant to be permanent by the founding fathers. So it went on and on. And on the other hand, Nirendi, again, appearing for the state, said that ultimately you will have to take into account the changing times. 1951, I was born. As I said, there was a radio at the top. Today, each one of you, as I said, are born with the internet. So there's a changing time. There are changing laws. There are changing thinking process. So, law cannot be dynamic. Constitution has to evolve itself to the needs of the people. Therefore, He said the argument of Nirandi was that amendment to the constitution as is propounded by the will of the people must be indicated. It is in this background that the Supreme Court laid its judgment. What did it say? Supreme Court held that it's okay. Golaknath's case was overruled. Golaknath's case said, fundamental rights chapter, there is no provision for the parliament cannot amend. So that was overruled. That means fundamental rights chapter, which encompass within itself several fundamental rights, that chapter also can be amended. But they said that Article 368 does not permit or enable the parliament to alter the basic structure of the constitution. It is this basic structure which has been expanded in the subsequent judgments, which has stood the test of time and which has saved the constitution. In spite of all this, we had emergency. Probably none of you were born. I was there in 1973 as a lawyer. 1975, I have seen the opposition leaders being jailed in Bangalore, but I was already a lawyer. Despite this Keshavananda Bharathi case, in ADM Jabalpur, Supreme Court went on to say and hold that Article 21 is virtually non-est. It doesn't exist when there is an emergency. Justice Y.V. Chandrachud, the present Chief Justice of India's father, was a part of that judgment. Subsequently, in 2020, in Puttaswamy's case, Aadhaar case, as we normally speak of about it, was reversed. Present Chief Justice of India, Justice Chandrachud, is a part of it. So he overruled his own father's judgment. Now, you may ask me, what is the basic structure? This theory of basic structure is not something new. Way back, during the Hitler's era, you go back, during the Second World War, prior to the Second World War. A German scholar, Professor Dietrich Konrad, he propounded the theory of implied limitations based on the experience of Germany and the misuse of Weimar Constitution of Adolf Hitler. There was a constitution brought about by Hitler. So he propounded this theory. Before the basic theory of basic feature of the Constitution was accepted by the Supreme Court, Justice Mudolkar, in 1965, in one of his judgments, he was one of the three judges who delivered that judgment. He refers to he concurs with the majority, expresses his misgivings about the absolute power of amendment of the Constitution by the Parliament. Please remember, 65 was before the Golaknath's case. 65 judgment was after the Shankari Prasad's case. Therefore, Mudolkar, in his judgment, says that the Constitution as originally framed can only be interpreted by the court of law, and the validity of any provision therein can be challenged, and the same cannot be said of an amendment to the Constitution. For an amendment to be treated as a part of the Constitution, it must in fact in law become the law when it is accepted by the Parliament and tested by the courts of law. So this theory of basic structure was there, floating around, but it was propounded with lucidity by Sri Nani Palkhiwala, and therefore we always say it is Palkhiwala who's the author of that judgment, though 13 judges authored that judgment. In fact, you may ask me, it is said, we all know, probably as constitutional history students, years back, Chief Justice Marshall of the US Court, a case came up before him. You know, during those years, 17th century, Parliament was supreme. Courts did not have the power to undo anything. But in the case of Marbury versus Madison, he held that the power of judicial review exists in the court. You know, that was something, though what he did was, judicial statesmanship lies there. He dismissed the petition, but said judicial review is permissible. You know, had he allowed it, there would have been reverberations in the nation. So that's why I always say judicial statesmanship is needed. He dismissed the petition, but said judicial review is permissible so that in future times, when people are able to comprehend what it is, they will, you know, go forward on that basis. So this is what it is. Ultimately, the basic structure was in 2016 in the Supreme Court Advocates Record Association case, Justice Kher Singh, who ultimately became the Chief Justice of India, he held that the basic structure of the Constitution inter alia includes supremacy of the Constitution, Republican and democratic form of government, federal character, you know, the distinction between the states and the center, the powers are divided, federal character, distribution of powers, secularism, separation of powers between the legislature, executive and the judiciary, and the independence of the judiciary. So he defined what is a basic structure. The basic structure as established by Keshavananda Bharathi's case has become a cornerstone of Indian constitutional ethos, and that, as I said, today holds the field. To sum up, we can only say this, that today the Constitution is what it is because of Keshavananda Bharathi. And we are extremely grateful to the Pontiff here because he was the one who filed the case. He lost the case. You know, look at it. Look at the irony of the situation. He challenged the constitutional validity of Kerala Act. His lands were taken away by the government. He lost the case. But legions of Indians will always remember him. The constitutional lawyers will always remember him until eternity. Thanks to him that Keshavananda Bharathi today is 50 years. We are extremely grateful to the MUT for this seminar that they have held. I only hope and pray that the younger students here, you are the future of the country. You are the future of the bar. We are all old. And you will carry forward this legacy. Wish you all the best.
Thank you, sir, for your very informative and educative speech. Now I call upon Sri Asaf Ali, Advocate, to take over the dais.
Respected President Mr. Prithviraj, the President, Mangalore Bar Association, the learned luminary, Senior Advocate and former Advocate General Mr. Uday Holla, Mr. Manikandan Nambiar, and eminent personalities, ladies and gentlemen. I am very much thankful to the organizers for having invited me to address this great function. Since my childhood onwards, this was my long cherished ambition to visit this holy shrine and premises. That my long awaited desire has been fulfilled today by coming here and addressing you. I would like to start where Honorable Mr. Justice Nagaraj concluded. He said it's a very great nation, India, surveys with the top eminence among other world nations. True, why? We got a very great beginning. Mr. Murkot Ramuni was a top bureaucrat in Delhi at the time of independence. Once he said, as a matter of fact, the Mountbatten decided 14th August as an Independence Day. And the Pakistan, the wounds of partitions were there. The Pakistan started the swearing-in ceremony on 14th. Some astrologers advised Pandit Jawaharlal Nehru, don't swear on 14th. It's a very bad day. Panditji never used to believe all these things. But eminent astrologers advised through Patel, don't swear on 14th. This message was conveyed to Liaquat Ali, can we have it on 15th? Liaquat Ali said, what? We all fought together. We can't wait for an hour, not for a day. The astrologers said, if you are taking swearing on 14th, the nation will be ruined. Then Pandit Jawaharlal Nehru suggested a via media. We'll start at 11. And asked Mr. Dr. Radhakrishnan to start a speech by 11 p.m. You conclude your speech by 12:30. After 12:15, the Patel had given a signal to stop and started swearing. The lady Mountbatten and Mountbatten came to quotes. So I would say our beginning was with a belief. I may not believe. That is why India, see, what about the fate of Pakistan? Pakistan quarreled and they were scattered into two nations. So our beginning is great. This Keshavananda Bharathi case, the impact of, when we are discussing about the impact of Keshavananda Bharathi, the eminent lawyer Mr. Neriman in his famous book, Before Memory Fades, would say, how influenced the Indian judiciary and Indian people the Keshavananda Bharathi. Neriman would say, before Keshavananda Bharathi, the role of judiciary was only an umpire in a cricket ground. He used to stand behind wickets and say whistle when the players goes wrong. After Keshavananda Bharathi, the tone and tenor of the judiciary totally changed. The role of umpire has gone. They became the referee in a football ground running after players. When the players goes wrong, he used to call penalty and penalize them and there. When the executive goes wrong, the judiciary is there aside. Because an umpire's role is only a silent spectator, but the referee is different. Now when the people goes wrong, the referee is there, the aggressive judiciary that is a protector of India because of this case. See, dear friends, Keshavananda Bharathi case was not a mere case. It was really a struggle for supremacy between Parliament and Supreme Court. The judges were divided, lawyers were divided. Just to see this, the total period, 6 months, 66 days, 13 judges. That period we could see from going through the history, it was not a mere ordinary judge. The judgment is also totally different. View of the majority is totally different. The Keshavananda Bharathi case, the impact of Keshavananda Bharathi, it has totally changed the constitution. I would say we are now following a US constitution, Article 21, not the Indian constitution because of this Keshavananda Bharathi. The first constitutional case, the fundamental case, I would say the A.K. Gopalan's case. What was A.K. Gopalan's case? A.K. Gopalan, a communist leader, was arrested and detained under Madras Public Security Act. It was challenged by the great eminent luminary Mr. M.K. Nambiar, the father of Sri K.K. Venugopal. The main contention of Mr. Nambiar was, you cannot send a person to jail solely on the ground that the procedure has been prescribed like that. Procedure established by law means a law enacted by Parliament or by Legislative Assembly. One judge alone dissented, one Fasal Ali said, no, not the procedure established by law, but due process of law. Supreme Court said this is the law. A.K. Gopal was arrested as per a law. There is a procedure established by law enacted by Parliament or the law enacted by Madras Legislative Assembly. The arrest was upheld. 28 years later, the Supreme Court, there is a Eureka call. Supreme Court said, we committed a mistake 28 years back. What we ruled 28 years back is not correct. That was the first judgment. Immediately after commencement of the Supreme Court, the first fundamental right case, the Supreme Court has committed a big blunder. They upheld the arrest of A.K. Gopal and said that it is an arrest under a law. Under a law means procedure established by law. Then there was a very serious argument in A.K. Gopal's case because at the time when the Article 21 was inserted in the Constitution, there was a Dr. B.V. Rao, the advisor of the Fundamental Rights Committee. That committee visited various countries including US. In US, he had a very detailed consultation with the Flourish. US Supreme Court Judge, Mr. Flex Frankfurter, and B.N. Rao simply asked, we have an idea to include the procedure established below in Article 21. The Felix Frankfurter said, no, you should not. Because if you are incorporating the procedure established by law, due process of law, instead of procedure established law, there will be a judicial tyranny. Then he decided no. In the committee headed by B.V. Rao, who framed the Constitution, presented a report to the Constituent Assembly that the procedure established law is the most viable and acceptable. But now we are not following procedure established law. We are following what? Due process of law. Because in the 99th Constitution Amendment, my learned friend would say, it was nullified by Supreme Court. That was an amendment, formation of a judicial appointment commission. The bill was brought by BJP government, supported by Congress, and left, and all other parties unanimously supported. In Rajya Sabha, only one dissent was there. That was none other than Ram Jethmalani. Ram Jethmalani alone opposed in Rajya Sabha. And 20 Legislative Assembly ratified it, Congress, BJP and all. When it brought to the notice of the Supreme Court, when it was challenged, Supreme Court said it is against the basic structure of the Indian Constitution. During the course of argument in the Keshavananda Bharathi, one Judge Dwivedi, who is very closely connected with the H.N. Bahuguna and supporter of Mrs. Indira Gandhi, simply asked, this is we the people, what is the meaning of we the people? We the people dedicated this constitution for the people, so how can you say? Then the Palce wala simply asked a question. Test constitutionality is not what a sane parliament may probably do, but an insane parliament can possibly do. Then Dwivedi asked, do you think that the members of parliament were insane? I am not saying like that. Dr. Ambedkar in the Constituent Assembly had made remarks about it. Who is insane or sane? The Ambedkar said, however good a constitution may be, it is sure to turn out to bad because those who are called upon to work it. However good constitution it is, however bad a constitution may be, it may turn out to be good if those who are called upon to work it happen to be good. So when it is entrusted to the bad people, even the good constitution will be worse. If it is happened to be entrusted to handle good people, even if the constitution is bad, it will work good. That is what the Palce said. If the test constitutionality is not what a sane parliament may probably do, but an insane parliament can possibly do. Palce made an illustration also. See, if there is a statute, underneath it is written that it can be amended. Does it mean, can you interpret that it can be amended, it can be remodeled, it can be demolished and remodeled? No. You can only make some amendments alone. Then the question is, there were total 6 cases. I respectfully agree the claim of mutt alone. Other cases I disagree. Which are the other cases? Mrs. Indira Gandhi, prior to 71 election, starts from Bengaluru AICC session. She declared some economic reforms. The main among them was nationalization of bank. The 14 banks were nationalized. It was challenged before Supreme Court. Immediately the declaration of nationalization came out. Palce took his friend Reverend Cooper, who is a shareholder, in his flight and started dictating even in the flight, challenging the declaration, proclamation of the president, taking over the 14 nationalist banks. The Supreme Court, when it challenged, Supreme Court said no. The amount and the compensation. As per the declaration, there is no compensation, only an amount by way of cash or by bonds. The Supreme Court said no, it is against, because the right to property is a fundamental right, Article 19(1)(f). So long as the right to property is there, the government has no power, no right to take over a property of an individual arbitrarily, which is in violation of the Constitution. In order to circumvent that judgment, the constitutional amendment was made in the 25th amendment, making some suitable changes in the Constitution, etc. And second one is the princely status of the Maharajas, privy purse, abolition of privy purse. That was also a declaration made by Mrs. Indira Gandhi prior to 71 election. That was also challenged because it is against the provisions of the Constitution. Because there is a provision in the Constitution at the time when they were merging with the Indian Union. They are entitled to get some status. You cannot simply make a declaration and abolish those. That is also under challenge by way of an amendment, that is 26th amendment. In Keshavananda Bharathi, mainly because the land reforms was challenged. What I could understand in the history, the lawyers of the Kasaragod bar is also deserves to be congratulated, because one lawyer from Kasaragod sent a letter to a Supreme Court judge, a Supreme Court lawyer, J.B. Dadachand. Dadachand, in consultation with the entrusted the brief to Nani Palce. Nani Palce said, this is not a mere land reforms issue. This is also an issue involved in the rights of a religious denomination under Article 25 and Article 26, 2 and 3. And the Palce reshaped the case and presented before the Supreme Court. Then you may ask, can you challenge these, the land reforms, etc., etc.? We can. That is what my learned friend was referring. The first constitutional amendment was necessitated. Why? First constitutional amendment was necessitated because immediately after the commencement of the Constitution, so many land reforms acts because the judges were all Zamindari representatives. The UP Zamindari Abolition Land Reforms Act 1951 was set aside by Allahabad High Court. Madhya Pradesh Abolition of Property Rights Estate Mahals Alienated Lands Act was also declared unconstitutional. And the Patna High Court ruled that Bihar Land Reforms Act is unconstitutional because we got the property rights under Constitution. Article 14, equality before law, equal protection of law. When testing this legislation with the Article 14 and Article 19(1) after right of property, this will not stand a judicial scrutiny. Then there is no elected parliament, no Rajya Sabha, no elected Lok Sabha, no provincial assemblies. Article 369 provides an amendment to the Constitution, majority in both houses, and the ratification of the elected legislative assemblies. Then there was a chaotic situation. Hundreds and thousands of persons were rendered landless. Then an advocate Chari, who is the Madras Advocate General, wrote a letter to Pandit Jawaharlal Nehru. An amendment to the Constitution highly necessary. Enacting some making some amendments in the Article 31B or C and inserting a Schedule 9 and including some legislations from judicial scrutiny, immune from judicial scrutiny. That was the result of the first constitution amendment which was challenged in the Shankari Prasad. Shankari Prasad, as per the subsequent judgments, Shankari Prasad judgment and also some other judgments and the first amendment as well as fourth amendment as well as 17th amendment made overruled by prospective overruling. It will not affect retrospectively, only the new constitutional dictum was shaped by Supreme Court. Prospective overruling. Similarly, some more amendments were made in the Article 19 because if the judiciary goes wrong at the beginning of the Constitution, when the judiciary goes wrong, there was a good referee parliament. When the parliament goes wrong, now there is a strong referee, that is Indian Supreme Court and High Court. Shyam Prasad Mukherjee, an eminent Hindu Mahasabha leader, started making very scathing attack against the formation of Pakistan. The Patel said to Nehru, see, unless, and Shyam Prasad Mukherjee went on to say, it is a high time to have a war with Pakistan. Then we can set the Pakistan, annex the Pakistan with India. And there is a relief and the refugee crisis. In order to shut down, that is what history says, in order to shut down such speeches, an amendment was carried out in Article 19 as per the first constitutional amendment. The state shall have the power to restrict, to make laws restricting any speeches which affects the public order, etc. If that is so, when the judiciary goes wrong interpreting the provisions of the Constitution and laws, the Parliament was there. Parliament has corrected, that is proved in the first constitutional amendment. And similarly, in one case, as per the Article 19(1), following the speeches of this Shyam Prasad Mukherjee, a restriction on the ground of anything which affects the friendly relationship foreign countries was inserted in the Constitution. Any speech made, we were all thinking why this provision has been incorporated in the Article 19. Anything which affects the friendly relationship with foreign countries. Similarly, when the abolition of Zamindaris was set aside by Supreme Court, the Parliament acted properly. When there is a scathing attack against the neighboring countries, the Parliament made some amendments. When there was a judgment of the Bihar High Court, Patna High Court, with regard to a printer and publisher published a pamphlet containing some very objectionable remarks which would incite a commission of an offense. A Durga Devi, a Sita Devi can make an appeal to kill a person. It is an Article 19(1), this is freedom of speech and expression. In the Patna High Court, an action was taken against the printer and publisher. The Patna High Court set aside, that was invoked a British legislation before the enactment of the Constitution. Then there is an amendment carried out in the Constitution that any speech, any act which incites the commission of an offense can be prohibited by making a law, it is a restriction clause incorporated. Then during the course of debate in the Constituent Assembly, Acharya Kripalani said, we need to incorporate some objections, only the violent offenses, an incitement of a violent offenses. Then our Rajaji said, there was a prohibition in Madras. If somebody makes an appeal to drink alcohol, it is a non-violent offense. Then if you are incorporating a provision, only violent offenses, incitement of a violent offenses, appeal to commit, violate the prohibition law is a non-violent offense. Then ultimately, incitement of an offense alone was incorporated. Just to see, my friends, whether there is any now I would like to have a critical analysis of this Keshavananda Bharathi case. There was no majority judgments, according to me, within my limited knowledge. One judge, Mr. Beg, was hospitalized. Even now it is a mystery under what circumstances the Beg was hospitalized. Beg was a pro-parliament provision. Parliament must have an unfettered power to alter, abrogate any provisions of the Constitution. Beg and Ray and Divedi and Matthew. The four judges were very much strong supporter of government that the Parliament must have unfettered powers to abrogate, alter any provision. That is what the Golaknath case would say. The Parliament has no power to make any law abrogating, altering the fundamental rights that is already there under 13(2). In order to circumvent that judgment, this Keshavananda Bharathi and other cases started following the judgment of the Golaknath case. Golaknath case would say that the Parliament has no power because Article 13(2) there is there. As per 24th Amendment, a proviso, a notwithstanding clause was also. This amendment, this law as referred to in Article 13(2) is not the constitutional amendment. So the Parliament must have ample power to make a law, to make a constitutional amendment, abrogating, altering or curtailing any of the fundamental rights. That is the principle in the Golaknath case. In order to get over that judgment, the 24th Amendment was made. In the Keshavananda Bharathi case, the majority view, there is no majority view. There is no majority judgment containing majority view. When the 13 judges sat together about to start, this Chief Justice Sikri made a very tactful manner. He prepared a memo, majority judgments. And all the judges signed it. Nine, not sign, I'm sorry, 9. 4 did not sign. We unheard. According to me, even if it is majority, the Khanna has done some wrong. Because Khanna has confessed that wrong in the Indira Gandhi's case subsequently. Because what is that 4? What is that 9 judges majority view? There are 5 Petition 135/70, 351 to 352, 373. Then there are 11 judgments which contains many views. But these 6 headings, the 9 judges prepared a note and signed. Golaknath case is overruled. Then is a big relief. Who won the Keshavananda Bharathi case? Whether the mutt or the government? Who? Because Golaknath case is overruled. The government has got power to make amendments curtailing fundamental rights. Then Article 368 does not enable Parliament to alter the basic structure or framework of the Constitution. That is a victory to all of us. All the petitioners can have a sigh of relief because we could obtain a judgment to the effect that the Parliament has no power to alter the basic structures of the or framework of the Constitution. That is what Palce said. When there is a statute and there is a footnote that you can make some amendments, it doesn't mean that you can remodel. And third, 24th Amendment is valid. Golaknath case is overruled and 24th Amendment is valid. How which will go together? And fourth, 2A and 2B of the Constitution 25th Amendment is valid. First part of Section 3 of the Constitution 25th Amendment, this is with regard to the bank nationalization, I would say. No law containing a declaration that is giving effect to such a policy, because this is a very, very important, which the Supreme Court said it is invalid. Because any law made on the basis of some of the provisions of the directive principles, it is valid. That is the proposition of the 25th Amendment. That part of the amendment, the Supreme Court said, invalid. And finally, 29th Amendment Act is valid. We lost. Mutt lost. It means what? Our case is that we have got the right to property. The Supreme Court would say the Kerala Land Reforms Act is valid. We would say that we have got the right to run a religious institution of our choice. Article 26(2). A religious denomination has got every right. If the Kerala Land Reforms Act 69 and 71 is made valid, what does it mean? It means that we cannot run our religious denomination of our choice. The Khanna in the later judgment said, I plead guilty. There is some discrepancy in the judgment, but unfortunately or fortunately, this has become law and saved the nation. Not unfortunately, fortunately, this has become law and saved the nation. What is Indira Gandhi's case? Those days, the judges were appointed by whom? At the whims and fancies of the central government. Not by collegium and all. My learned friend read the dissent of Mr. Chelamesher. See, the 99th Amendment was made null and void because can a litigant be appointed, it can be given a power to appoint a judge. I am a litigant. I am giving the power to appoint a judge. That is a principle in the second judge's case and third judge's case in the 99th Amendment Act. Chelamesher said there are some discrepancies. Okay, I do agree. But what about the role of litigant? The litigant, if the judges are given the power to appoint judges, okay. But what about the litigant is an interested party? If the litigant is given the power to appoint a judge, there will be a chaos. The judges will have to act as per the whims and fancies of the government. That is what I would say. The Chelamesher dissent has no value at all. Because the judge cannot be appointed by the government. Government is the biggest litigant in the country. That is what I would say. At any circumstances, and some unpleasant things happened after the judgment. Because the Palkewala would say in his biography, even during the time when the hearing was going on, not the lawyers quarreling, but the judges are quarreling. The 4 judges are one side, and the 9 judges are on another side, 7 judges are on another side. 2 judges are somewhat impartial. That is Mr. H.R. Khanna and Mukherjee, if my memory is correct. They were quarreling, they were answering. Nowadays, the things would have been made many problems in court hall if this Keshavananda Bharathi scene enacted any of the courtrooms. 24th April 1973, some media reported the draft judgment were on the floor of, on the table of Law Minister and Prime Minister Mrs. Indira Gandhi. At 5 p.m., All India Radio made a declaration. The next Chief Minister would be Mr. Ray. Junior most, the Ray was appointed after superseding 3 judges. Grover Shelath and one more. Hegde. Grover Shelath and Hegde, 3 judges. They resigned. You just imagine such things happen now in Delhi. There will be a very big disaster in the judicial administration. And Indira Gandhi's case, what was Indira Gandhi's case? People would say during the period of emergency, the judges were crawling when they were called upon to bow. No. Even during the period of the judicial hegemony could withstand because of the law laid down by the Supreme Court in the Keshavananda Bharathi case. An amendment, 39th amendment, which made a special immunity to the Prime Minister and Vice President and President, was declared null and void by the Supreme Court. Can you imagine it? During the time of emergency, this was happened. During the time of emergency, the 39th amendment was declared null and void by Supreme Court. And in that case, after that case, before that case, there was a move to review the principle, the case of the Keshavananda Bharathi. I believe now that was saved none other than by Palkewala. When the matter was, when there was a move to review, the case was numbered, and the Tamil Nadu Advocate General was sitting there on 20th October 1975. A move by the Supreme Court to get it reviewed at the instance of the central government. Palkewala wrote a letter to Mrs. Indira Gandhi. Palkewala said that letter had its effect. That move for review in the Keshavananda Bharathi case did not bear fruit because of my letter. I may be permitted to read some portions in the letter, my dear Indira ji. He felicited her on her victory in the election appeal, praised her personal qualities, but implored her in the interest of the nation to stop reconsideration by Supreme Court of what he considered as most vital doctrine of the basic structure of the Constitution. He pleaded that if Parliament was given an unlimited power of amending the Constitution, democracy, the unity and integrity of the country would vanish. And after there would be nobody to hold the entire country together. He wrote that the basic structure of the Constitution was real safeguard of the minorities, and with the limited amending power, the rule of law would disappear. He stated that her own election appeal had been argued in the Supreme Court on the basis of Keshavananda Bharathi case, represented by the law and the land, and it would be strange that within 3 days of the historic judgment in her favor, the case should be overruled. He concluded by writing. This paragraph is very, very important. He appealed to Mrs. Indira Gandhi. Hearing of the Supreme Court on the correctness of Keshavananda begins tomorrow. It need not continue unless the government wants it to do. Believe me, my respectful appeal to you is not made out of any lack of confidence in the case. Palce was very confident that the review could be defeated. But even then, in the case holding Parliament's amending power to be limited, but it is based upon my belief, it would be great gesture on your part to withdraw the state plea for unsetting the law. I shall be very happy to call upon you if you desire. Another portion I am not reading, even in another portion is said, it is because of you the nation could be saved. And if another man comes in the place, what the Dr. Ambedkar said, if it reaches in the hands of bad person, our constitution would be worse. See, American Constitution. Our Constitution have 448 articles. American Constitution is only 7 articles. We have 105 amendments. American Constitution have only 27 amendments to 7 articles. The longest constitution in the world. Here the people are masters. Not the Indians alone. In one judgment, Supreme Court said, those who are living in the territory of India are protected under the constitution. In one case, one Bangladesh lady was raped and murdered in a railway Yatri Niwas in Calcutta. An advocate took up the matter by claiming public law remedy. The Calcutta High Court granted compensation, directed the Indian Railway to pay compensation to that lady. Because it is the duty of the Indian Railway to see all are protected by their life and liberty. The matter was taken up before the Supreme Court. The Supreme Court, 2 contentions were raised. One is the locus standi of a lawyer. I would say the members of the legal fraternity, you must come to the occasion, rise to the occasion, and come to the rescue of the innocent people who are being murdered in the lockups of Kerala jails. Supreme Court said an advocate and advocate association has got every right to take up the matter. And further said, there are differences between Article 19 and Article 21. Article 21 said, no person shall be deprived of his life and liberty. No citizens. No person. It would say no person. It means what? Right from a judgment of the Supreme Court, Rudul Shah versus State of Bihar. If anything happened by the hands of state and state instrumentalities, in violation of the fundamental right, it is the duty, it is the bounden duty of the state to pay compensation. Right from 1980, that is the law. Our constitution is sacred. It is made more sacred by virtue of this judgment, which is reasoned by this mutt and pontiff, made an effort, a simple effort. How we got prominence in this case. Andyarjuna in his book would say, how the Keshavananda Bharathi case, Madhavarau's India case and other cases are there. The mine owners of the Maharashtra and the dethroned kings and princes of Travancore and northern India. A profound constitutional scholar, Sirvai, rendered assistance to Nirande, Attorney General. On one condition. What was the condition? I must give the first preference to start argument. It is not fair to sideline the Attorney General. The matter was considered, discussed with K. Karnakaran and Achyuta Menon. They suggested we will engage Sirvai, then he can start. Before commencing the argument of the Attorney General, the Kerala state was represented by profound constitutional scholar, Mr. Sirvai, and Sirvai stood up and started his argument in favor of government. Those were all futile attempts. But fortunately, we got a judgment that is a surviving Now India survives because of Keshavananda Bharathi alone. Protector of this great nation against all attacks from within and outside government and all elements. Here we are the masters. An ordinary man is a master. If you are writing a letter to Supreme Court judge, the letter will be treated as a writ petition and you can expect a relief. Even if be you ever so high, law is above you. India is a country of rule of law, not rule with the law. Even if one party gets majority, no use. Now the government of India is thinking to reshape one nation, one election. I may be excused. Is it possible? One nation, all assemblies dissolved, parliament dissolved, one nation, one election conducted. Then a group of MLAs defected and 2-3 assemblies dissolved. Ministry resigns. What would be the fate? Just to think. One nation, one election. After the election, 2-3 assemblies had to resign, chief minister had to resign for want of sufficient majority. What would be the fate? Can they wait for another 4.5 years? One nation, one election. It is absurd, I may be excused. So even if you are having the command of the majority, ordinary man, me and you have a weapon of the great constitution which is made more strong by the law laid down by this great pontiff, His Highness Keshavananda Bharathi. We bow before your holiness for having saved this constitution. See the constitution of Australia. The provision is alter the constitution, not amendment. The framers of the constitution applied their wisdom and suitably enacted amendment alone, not altering, not abridging. That is what the great gentleman, the legal scholar, Dr. Ambedkar would say. This constitution can reach in the hands of bad person and good person. Even if it is bad, even if it reaches to the good person, it will be good, it will be best. So dear friends, we are all very, very happy to be here to discuss this great judgment. This is not a judgment. This is not an ordinary judgment. Where it is a judgment. No. The judges quarreled, lawyers quarreled, inside and outside court. 13 judges sat together and decided the fate of a great nation, that is Bharat, India. I conclude. Thank you.
Thank you, sir. Next part is followed by open session. Is it there?
I thank both the prominent resource persons for their wonderful seminar. I'm sure everyone gained a lot of information. Now the session is open for interaction. The question and answer sessions will be appreciated. Now the gathering can raise their queries. So, I have a question. Whether the collegium of the judges comes in the basic structure?
See, is it not? Because in the 99th Amendment Act, had to ratify 20 assemblies. The judiciary is a part and parcel of basic structure. It is answered, with my information is correct, in the second judge's case. Otherwise, the collegium would not have been lasted long, because a very aggressive executive was there to see it is defeated. Election is a basic structure, even according to Keshavananda Bharathi. If the election is a basic structure, secular nature, federal nature are all basic structures. Why can't judiciary? You want the collegium system? Change the collegium system. Subject to, within my limited knowledge, my learned friend can correct also if there is anything wrong.
There is always a debate. I don't think anybody can say that, well, this is the correct system. One of the things that have always been against the collegium system is judges appointing themselves as judges. What happens to the will of the people? Of course, one argument, as Sri Asif Ali very prominently pointed out, litigant appointing the judges. It's like cricket players appointing the umpire. That is one argument. Other is, please remember, if the judges themselves appoint judges, then what happens to the will of the people? We are 130 crore people. When the parliament is formed, it is the will of the people that is there in the parliament. If the parliament does not have the power and the parliament appoints the executive, if it does not have the power to appoint the judges, then if only the judges appoint themselves, does it not tantamount to nepotism? So these are debatable issues. There is no one single answer to it.
I respectfully disagree, because the judges are not the stakeholders. Some nepotism will work, definitely. That is what recently the Supreme Court said, that the Kerala High Court appointment as district judges are all null and void, but unfortunately they are continuing. But they are not litigants. When there is a fight between litigants and the litigant is given, because who is the biggest litigant in the country? Government. Government. Even now, still I remember the speech of Mr. Arun Jaitley in the Lok Sabha. See, in the Constituent Assembly debate, there was a heated discussion to bar retired judges from holding any posts. Ultimately, the debate concluded that bar to the PSC and UPSC members instead of judges. Judges who are nourishing the hope of getting a suitable berth after retirement will undermine. I do agree. But that danger is less danger than giving the power to litigant to decide my judge. If I am getting a power to appoint a litigant, when I am arguing before the judge, what would be the fate? The judicial system will be a casualty according to me. I do agree, respectfully agree with my learned friend, because there are chances of nepotism, sure. But that danger is less than giving the power to litigant to appoint a judge. That is why I agree with, because in Keshavananda Bharathi, 4 judges, they were keeping very hot line with Mrs. Indira Gandhi and H.N. Bahuguna. And the draft judgment was reached on the table of Mr. H.R. Gogale, the law minister. That is what Palce would say after the judgment. If that is so, that would be very, very dangerous. That is what I say. I prefer the lesser evil system, judges giving appointments to judges.
I wholeheartedly agree with him. I said there are 2 views. Now look at world over. Which country appoints the judge? In which country do the judges appoint themselves? So this is another facet, but I would wholeheartedly agree that this is a better of the systems.
In world country, just see America, the Trump was an order passed against Trump by whom? The judge appointed by Trump under his own. And those judges did not agree with the coup coup, a peaceful coup attempted by Trump to disrupt the swearing ceremony of the new president. That is the impartiality. What about the Watergate? A district judge passed an order against Nixon, Clinton. In Watergate, he had to step down. Our system is totally different. In England, my Nagesh was referring to England. Immediately after resigning the post of the president, Prime Minister Margaret Thatcher, one of my friends would say, Thatcher was queuing in the metro railway station as an ordinary man. Can we imagine? In Kerala, Chief Minister moving with hundreds and thousands of police. That is totally different from India.
I would like to make an amendment while appreciating the argument of both of you. Why not lawyers' associations and senior lawyers propose the name of the judges? Because they know who is best and who is not best, or who is good and who is not good.
And you will be practicing before the judges. Therefore, the judges know who is the better of the persons. Because see, one of the argument in favor of collegium is, please look at it. Person from Kerala is to be appointed as a High Court judge. What do the Prime Minister know about him? The judges know whether his hands are clean. Because please remember, judges' hands must be clean. They must be impartial. If it is not, if he has some taint, then he will not be a good judge. Therefore, whether his hands are tainted or not, mere IB report will not indicate it. Therefore, judges appointing, the judges has its own, flavor, and I would agree with my learned friend that, that's a better system out of the two.
But only when they appoint their children, kith and kin.
That is totally different. Even during the period of Mrs. Indira Gandhi, as rightly pointed out my learned friend, she had some intelligence from other sources. The best example is B.R. Krishnaiyer. B.R. Krishnaiyer was a candidate of Telishri in my place as a lefty MLA. He was a minister in the communist government. That Krishnaiyer, when resumed his practice in High Court, he was suggested by whom? Mr. Mohan Kumaramangalam, his colleague in Madras Assembly and a lawyer. And he suggested Indira Gandhi is the best lawyer to be suggested as a judge. When Indira Gandhi because his appointment was initiated by Kumaramangalam and H.R. Gokhale, on the very day when he heard the judgment, the appeal of SLP of Indira Gandhi, Mr. H.R. Gokhale asked an interview to Mr. B.R. Krishnaiyer. He asked for what? Because the case is now before you tomorrow. No. There you are a litigant, I am a judge. Sorry to say, I cannot give you an interview. He passed a judgment. See, that judgment is a very, very important judgment in history. Palkiwala coined a defense. What was the defense? There must be some compelling circumstances to grant stay to Indira Gandhi. What was the compelling circumstance? Congress party convened twice and decided we will elect none other than Mrs. Indira Gandhi. If that is so, there will be a constitutional crisis. In India, there will be no Prime Minister after 2 weeks of the judgment of the Allahabad High Court. Krishnaiyer said, yes, there is a remedy. She can continue as Prime Minister. Mr. Nani, you are very particular. We will lose a Prime Minister. She can continue. She cannot vote. She cannot participate in the debate. She cannot receive salary. What else? That was Mr. V.R. Krishnaiyer. There are good politicians, proved his mettle as a good judge. But there are bad judges who had joined in politics after the retirement. Sorry to say, Mr. Gogoi is the best example for it.
Sir, relating to this one, as judicial system of India today is accused of corruption, nepotism and political bias, so how can we re-establish judicial statesmanship, as you mentioned in your talk? So what is your advice to young lawyers assembled here?
First thing that everybody should remember is there's a crumbling value system in our society. To the youngsters, let me tell you this. When I came to the bar, I joined a criminal lawyer because you read Perry Mason and you are thrilled by the criminal jurisprudence. For about 8 months, he didn't pay a penny. Then, having no other choice, I joined my father's office. He paid me a princely sum of 50 rupees. I didn't have money in my pocket. My pride didn't permit me to accept from him. I had to sell my first day cover collections because I didn't have money. But one thing I always said was, if there's no case, I told the clients, please don't, because I saw my father doing this, that if there was no case, he told the clients after studying, please don't pay fee to me, please don't waste your money, please go. I followed that. Ultimately, initially when I started it, my colleagues, my friends would say, do you have they'll make fun of me. Do you have family to maintain or not? I said, it doesn't matter. My conscience is more important. Ultimately, everybody whom I sent became my advertisers, and my practice flourished. Why I am saying this is, hands should be clean, heart should be clean. Keep that alive. Today, unfortunately, my friend here said, he gave the example of Krishna Iyer. That example itself is sufficient to say that collegium system is not needed. But then, as he very rightly pointed out, those were men, those were the days. Today, value system is crumbling. Youngsters, today you are the future of the nation. Please remember this, honesty always pays. Honesty and integrity is at a discount today. If you don't, then India will not flourish. India will not become number one nation. If it has to become number one nation, please remember this. My learned friend said that Margaret Thatcher was on the railway station after resigning. In fact, in Madras, if I am not mistaken, I don't remember his name, after Kamraj's appointment. No, Kamraj is one. Thereafter, there was one chief minister. After resignation, he was in the bus stand the next day. We had an example in Karnataka. Sri Kadidal Manjappa was the chief minister. He, after resignation, started practice. Why I am saying this is, those were men of values. Those were men who had honesty and integrity. And if you have honesty and integrity, nation will progress. Please remember this. Each one of you, pledge yourself that there is so much of corruption in different forms. I would beseech to every one of you youngsters, you are the hope of the nation. Please remember, your hand should be clean, your heart should be clean. You will succeed and you will achieve greater heights.
Thank you, dignitaries,
Sir, the problem is nepotism is always there in any system of administration. If there is a collegium or in the part of the government. Then what about this is an independent national judicial commission in line with this civil service commission? What is your opinion about that, sir? A national judicial commission in line with Indian civil service.
What happens is, that is what I said. You do not know whether he is competent or not. So we all see in the television. Sorry. Can you hear me? I think I am loud enough. I think his voice is louder than mine. Yet the mic is favoring him.
Yes.
That shows that he is a better lawyer than me.
Yes. It's not like that.
See, judicial system requires that they must be competent men, persons who are capable of arguing. We all have seen people will be arguing 1 minute before the Supreme Court. I don't know how many of you have gone to the Supreme Court. They would argue for a minute. Well, most of the time the papers are flung down and they say dismissed. He comes outside and on the TV he'll argue for 15 minutes. Now, if you have a judicial commission, they will think that he is a better lawyer. But we all know, judges know who is a better lawyer because when they practice before him. And that competence, judges can gauge them, not the judicial commission. Because as I said, look at some far-flung, in Kerala, there is a judge. There in Karnataka, there's people sitting in Delhi and the judicial commission of five people, say for example 5 people. What will they know about the competence of the person? They will assess it on the basis of, somebody has told me that he's a better lawyer. Somebody has said he's a better person. Now, how do you assess it? Judges, when we practice before the judges, they know who is a better lawyer and who will become a better judge. And judgeship is not that easy. Please remember, judgeship is an extremely arduous task. You must be partial, impartial, you must be able to hold the balance even. And that requires a great deal of erudition, great deal of tact, great deal of honesty and integrity. And that the judges will be able to assess on the basis of lawyers' performance in the court, not outside the court.
Our civil service is shaped in a subservient culture. Yes, man to minister. However, you make it sure that independence among the civil servants, you cannot expect a desired result. That is why in all corruption cases, A2 and A3 will be the collector or the MD. Sure, but judge is totally different. That is what I pointed out the example of B.R. Krishnayar. B.R. Krishnayar, Mohan Kumaramangalam, H.R. Gokhale are thick friends. Krishnayar himself had disclosed all these things. How high shaped to get over the argument of Nani. We must have that culture. That is, my learned friend said that the judge alone can understand the capability, proven integrity of a lawyer. He may be very scholar, but if his integrity is dangerous, the judge can point it out.
Sir, Krishnayar was one of the members of another generation of politician. We cannot expect such quality from these nowadays politicians.
That is why collegium system.
Sir, both of you are different on views. One says that collegium is best, and you says that.
No, I don't say that. I said there are two views possible.
Yes. So therefore, mine is an alternative suggestion.
Of course, no doubt.
Why can't a National Judicial Commission? I don't think, sir. I don't think a young IAS officer can be a good judge also. He's an executive magistrate also.
No, sir. No. You had ICS.
Yes.
ICS judges. Yeah. In fact, if you look at the
Privy Council
history, there were a couple of ICS judges.
Yes.
They were not lawyers. They were really good judges. Ultimately, judgeship is something which you are able to come up to the fore at the time when you take over that.
Hello, what I am telling is,
What I am telling is, these things, both opposition and ruling party are same. Who is the creator of National Judicial Commission? Not BJP, but by Congress.
Yes, yes.
Veerappa Moily is the father of it.
Yes, yes.
And when the matter reached in Lok Sabha, both of them agreed.
Yes.
What is the provision? The Prime Minister has got a veto power to appoint a person of his choice. None did oppose, including left in Kerala. They all supported. Because of the Keshavananda principle and the Supreme Court, a very danger was saved.
Okay, sir. Thank you, sir.
Sir, I have a doubt in my mind. It's not a question. Let me put my doubt before you. Whether the Supreme Court is a constitutional court or an appellate court, or whether there is a possibility of Supreme Court acting only as a constitutional court and separate judicature for appellate authority will be appointed, anything in near future?
Our Supreme Court is both appellate court as well as a constitutional court. Maybe in the US court, it is more constitutional than anything else. In fact, way back in 2005, I had gone to the US Supreme Court. The Supreme Court there is totally different. I was sitting in the court of not 2005, but 1990. In the US Supreme Court, people are given time. Maximum time given is half an hour. I was in the Supreme Court, arguments were going on, a lawyer was arguing, red light came, halfway through the sentence he sat down. Does that happen in India? Answer is no. We will keep on arguing. I remember Justice Balakrishnan, after his retirement, he said, why are delays so much? Because senior counsel will keep on arguing till the cows come home. Cows come home only in the evening. Therefore, all that is said, the Constitutional Court. Now please look at our, when 2005, I was again in the US Supreme Court. I had met Justice Scalia, Alito, who is of Italian origin. He very proudly said, we write 100 opinions every year.
Now imagine 100 rupees, 100 judgments. I was tempted to tell him, every day in the Supreme Court, judges write, every judge writes, something like 60, 80 judgments. So that's a different thing altogether. In the US, it is a constitutional court. In India, it is both appellate court as well as constitutional court. Yes.
Mr. K.K. Venugopal put forward a suggestion before the Union government as the Attorney General, a new idea of National Appellate Court. National Appellate Court, because nowadays the Supreme Court spends lion's share of the time in the 138 appeal, criminal appeal, etc., etc. Because the pendency is increasing and the serious constitutional cases are being delayed. That idea is still there alive. Provided the government of India will have to agree, there must be a constitutional amendment also.
Thank you, dignitaries, for thoroughly clearing all our doubts, and also I thank the participants for participating in this open session. Now may I invite Advocate Shri Manikandan Nambiar K, the President Bar Association Kasaragod, to propose the vote of thanks.
His Holiness Sripadanglavaru Bharathi Swamy, most respected Uday Holla, former Advocate General, most respected Asaf Ali, former Director General of Prosecution, Kerala, Mr. Prithviraj Rai, respected principals of various law colleges, respected President and office bearers and members of various bar associations, ladies and gentlemen, we are almost concluding our session, today's program, and this is the last vote of thanks is the last thing. Before that, I may be permitted to have a glance on all of you to enrich or cherish my taste for history. Because even though it's a seminar, I feel this is as a reunion of a joint family. Because the Udupi districts, Dakshin Kannada and Kasaragod district are the part of the earlier Madras presidency. And when in Onam times, the every members from the various countries and part of the nations come to join the Taravat for a feast and for some leisures. So this, even though the Onam is over by a few days ago, still I feel that this is a rejoining of the old Taravat members. Very glad to see all of you. After a very good feast with the two payasam, the last is the Mosaru Uta, the Anna and Mosaru. The vote of thanks is such a way. So the person who is serving Mosaru and Uta, they will vanish very quickly. So I have to vanish quickly. After the long sessions and after a good two payasam, I think your sugar level is not increased, but the basic structure of your brain is improved. We are grateful and we have no words to express to Mr. Uday Holla, who readily accepted and came here, and for his great presentation and presence. Thank you, sir.
May I now request Srimati Akshata, the principal of Vivekananda College, Puttur, to kindly offer the memento to Sri Uday Holla, the Senior Advocate High Court of Karnataka and the former Advocate General of Karnataka. Thank you, ma'am.
Yes. Mr. Asaf Ali is a very well-known person in Kerala. He is an evergreen panelist of the news debates in the evening. In every TV, he will present his debates. So he is familiar to all of us. Sir, we are grateful for your presence and your presentation in this August gathering, and we are always grateful and express our deep gratitude and thanks to you, sir. Thank you very much.
May I request Advocate Thomas D'Souza, Advocate of Kasaragod, to kindly offer the memento to Advocate Sri Asaf Ali, the High Court of Kerala and the former Director of General Prosecutions. Thank you, sir.
Sir, I express my gratitude and thanks to Mr. Prithviraj Ray, who was the moderator of this function. Actually, he is the guest, not a host. Still, as a formality, I express my gratitude and thanks to Mr. Prithviraj Ray. So whenever we thought for a seminar, of course, the great orators, their name came. But the next option that there must be some students of law as the audience. We are very grateful for the students and their participation and presence here, and for which we are we are grateful to the head of the institution of Mangalore, Udupi and Puttur. Sir, thank you for all the heads of the institutions, law colleges of Puttur, Udupi and Mangalore. And Sulliyattu, sorry. I'm sorry, Manjeswaram too, Manjeswaram. And all the presidents and office bearers of the Bar Association of Mangalore, Puttur, Udupi, Kundapura and Beltangadi. Thank you, sir. Thank you all. And once again, I congratulate and express my deepest gratitude to the students who was patient here to sit here in the sessions and cooperate with us. Thank you very much. And thank you. I express our gratitude to the teachers and staff of this Swamiji's Higher Secondary School and all the persons who have contributed by their efforts and their help to make this function as a grand success. Thank you, the lawyers of Kasaragod and Hosdur. Thank you, everyone. Thank you very much. Thank you.
The lawyers from Karkala and Modbidri are also present among us. I also thank them.